of Justice.
Let's call the matter.
Caribbean Court of Justice Appeal No. CV1 of 2007 between Toolsie Persaud Ltd and Andrew James Investment Limited, Shivlochnie Singh and the Attorney General of Guyana.
It please your lordships, Mr. Ramlogan and Mr. Shatram are with me for the appeal.
Thank you, Sir Vendon.
If it pleases your honours, my name is Ashton Chase. I appear for the first name respondent. The Honourable Mr. Singh, Senior Counsel, is with me.
Thank you, Mr. Chase.
Mr. Boston, Mr.
Thank you, Mr. McGee.
May it please you, Your Honours, I appear in Mr. Vashish Maharaj and Ms. Martina Bacchus.
Thank you, Mr. Attorney. So, before we start, I would refer to a letter which I think Council will have received from the Registrar indicating the time limits within which we would ask Council to contain their oral submissions. We have received and read with interest the very detailed written submissions from all the parties. And in the light of those submissions and their comprehensiveness, we don't think it is necessary to have very extended oral submissions. The proposed time schedule is that the appellant would be asked to open the appeal within a period of 90 minutes, and that the respondents should together make their submissions in reply within a similar period of 90 minutes, and that the appellant would then have not more than half an hour, if necessary, to reply. So that we would ask our Council to respect those time limits. With regard to the hours of sitting today, we propose to sit from now until 12 noon, when we will take a break for lunch of 1 hour, and we will resume at 1 o'clock, and then hopefully finish by about somewhere between 2 and 3. All right, well, Sir Fenton, would you like to open your appeal now?
Lords, there are three simple events in this matter, which have caused tremendous confusion and difficulty in the courts below. And they are the making of acquisition orders in 1977, the sale to the appellant in 1987, and the nullification of the acquisition orders by a judgment of the High Court confirmed by the Court of Appeal. Judgment of the High Court, delivered in May 1990, was to the effect that the perpetuated acquisition was contrary to the provisions of the Acquisition of Land for Public Purposes Act, Chapter 6205. And the main ground of the judge was that compensation had not been voted or paid by the National Assembly. He considered that no constitutional rights had been breached. But when the matter went on appeal to the Court of Appeal, the Court of Appeal, in an order made in 1995, affirmed the judgment of the High Court insofar as it set aside the acquisition of three of the parcels which are the subject of the petition in this case, and made a further declaration that the acquisition was unconstitutional and bad in law. That created a difficulty because it meant that so long as the state was in possession of the land, thinking that it was in possession by virtue of the acquisition orders, the state was proved by the Court of Appeal and the High Court to be mistaken because the acquisition was ineffectual. But that did not alter the character of the possession of the state. The state was factually in possession with an intention to possess all along. In relation to parcels F, G, and H, the state was in possession for 1 year by a permission granted for agricultural purposes from July 1974, but the state remained in possession, and in 1977 the acquisition orders were made.
Before you continue, Superintendent, you say the state was in possession from 1974 with permission for 1 year.
Yes.
But was there not a finding of fact by Chief Justice Singh that, in fact, the permission, whether it was expressed or implied, continued up to the time when the order for acquisition was first made?
There wasn't such a finding. My difficulty with that is, may I say briefly, the permission was expressed to last for 1 year, and there was no further evidence that it was extended. The judge said that they continued by an implied permission, but I don't think that the documentary evidence supported that conclusion.
But the problem is that finding was not upset by the Court of Appeal and is not the subject of challenge before us.
Well, the reason why I do not make much of the Court of Appeal's decision in that respect is that however one looks at it, whether the permission was implied after the 1 year expired or not, it could not go past the making of the acquisition orders in 1977. And if the 12 years were to be counted from that time, in 1989, the title of the paper owner would have been extinguished. That's the submission I make.
Well, in relation to areas F, G, and H, the proceedings to challenge the orders were launched on the, I think, the 20th of March,
Yes.
1989.
Yes.
And the first of the acquisition orders was published on the 28th of March, 1977.
Yes.
So I don't know, it would appear that if time started running on the 28th of March, 1977,
Yes.
it hadn't quite run out the 12 years when the challenge was launched.
That is true. But, my lords, the position is that the proceeding which was launched in 1989 March was not a proceeding to recover possession. It was a proceeding aimed at achieving this result, that the acquisition orders upon which the state was relying for its possession were unlawful. But there was no action to recover possession. So it did not matter in my submission that the proceeding was brought in March 1989 before the 12 years had expired. That might have been so. But it was not a proceeding in which the paper owners of F, G, and H sought to recover possession, which they could have done in the same proceeding.
But, Sir Fenton, did they not actually claim that in the motion on the 20th of March, that they wanted the order set aside and they wanted to recover possession and title to the land? And that's why that was ordered by the judge in the end of the day in 1990 and affirmed by the Court of Appeal.
In 1990, the
Have a copy of the motion of the 20th of March 89 to see what was requested.
What volume can you help him? Where is that to be found? I don't know, is that on the record? It would have been a constitutional motion, wouldn't it?
would have been a constitutional motion.
I think the judgment of Mr. Justice Kissoon is in the supplemental record.
Yes, and the order does not speak about the recovery of possession. The judge made no order for recovery of possession. That appears from...
So, Fenton, now if you look at the if you look at the supplemental bundle,
Yes.
you will see at tab 5 or tab.
Tab 5 of the
Sorry, I think it's tab 4. Sorry. You will see towards the end of the order, it says it is further ordered that the applicants do recover against the defendants. No, sorry, it doesn't say land.
Yes. It's on page 5 of the supplementary report.
Yeah. Yes, I thought it was going to say recover the land, but it doesn't.
It said that the acquisition would be set aside as being contrary to the provisions of the Act. It's further declared that the schedules purportedly made are ultra-vires and barred, and it is further ordered that costs be recovered.
That's the order of whom?
Kissoon Day.
And on the next tab, all the Court of Appeal said was that the purported acquisition would be set aside on the ground that the said purported acquisition was made contrary to the requirements of the Acquisition of Land for Public Purposes Act. And this court does declare that the aforesaid purported acquisition was and is unconstitutional and contrary to law. It does not seem as if the parties intended that there should be any order for the recovery of possession. It certainly was not fought for. Or else one cannot understand why the judges, either in the High Court or in the Court of Appeal, did not pronounce an order for the recovery of possession. It would be much too late to do that now.
In the bundle of authorities which you submitted,
Yes.
the judgment of Mr. Justice Kennard, does he not there set out what the constitutional motion said on the 20th of March, 1989? Page 2. Page 2 of the...
He might have done, my lords. I don't...
I mean, this is second hand, but I mean, this is the nearest we've got to what...
What does it say?
It says, filed a constitutional motion in the High Court in which they sought a declaration that their fundamental rights as transported owners of areas F, G, and H, etc., have been or is likely to be contravened by certain acts of acquisition by the state of Guyana. And B, a declaration that in law and in equity, on the non-fulfillment of the purposes expressed in the acquisition for land and for public purposes, etc., act, the aforesaid property reverted and still does properly belong to the appellant, and their transports therefore are valid and effective. C, further and or other relief, a declaration that the aforesaid purported acquisition without compensation was violative of the applicant's constitutional right and law. And then damages and further or other relief and costs.
Yes. They wanted damages for breach of the rights and they wanted costs.
Yes.
So no claim was made for possession. They wanted damages and costs.
But I think the respondents argue that that to recover possession required a two-stage procedure. This was the first stage, and that therefore the right to recover possession did not accrue until this judgment was given.
That is their stand, and it has to be analyzed, my lords. I don't think it's being contended that when these unlawful orders were made, that they could have waited for any amount of time to challenge them. And then, after they had waited, in this case they had waited nearly 12 years before they issued a challenge, then say that, oh, we had to have this determined before we could bring an action for possession. When we all know that the action for the recovery of possession could have been brought at once. And if the orders were set up in defense to the action, it would have been possible to put in a reply saying that the orders are unconstitutional and have the matter determined there. But we couldn't wait 50 years for an action to set aside the orders to take place.
But it would not have been sensible to launch an action for possession, ignoring the compulsory orders which had been made. Surely, what I would have thought you were submitting was that in the action for setting aside the acquisition orders, one part of the relief claimed could have been the recovery of possession.
Yes.
But you say they did not claim, or did not expressly at any rate, claim possession.
No.
And that therefore this action, this constitutional motion, did not stop time running. Is that right?
That's our submission, that it didn't stop the time running. Constitutional motion which did not ask for an order for possession did not stop time running.
On the other hand, Sir Fenton, it did seek a declaration that the aforesaid property reverted and still does properly belong to the applicant.
I have no doubt that is what they...
And it asked for such further another order and declaration as to the court seems just, which would obviously include saying, well, since the title belongs to you, you're entitled to possession of it.
The court could have said that, but the court did not say that, and they weren't asked to say that. The court could have said that. But the court were not asked to say it, and that's why the court did not say it.
But, Sir Fenton, what would be the point of trying to set aside the acquisition orders? Would not the logical step after that, assuming you were successful, be to bring an action for possession?
Yes. I have no doubt that that is so. But that forgets that time under Section 5 of the Act was running.
But then...
Those who waited until 1989 to launch the proceedings to set aside the acquisition, which in any regular system of law they would not have been able to do because that delay was far too long. But they managed to get an order setting aside the acquisition. And having not asked for possession, Section 5 of the limitation statute ran against them, and their titles were extinguished under Section 13.
But I don't know if there is any authority on this, but it might be argued that if you bring proceedings which challenge the whole basis on which you have been dispossessed, that if you don't in explicit terms, even though you don't ask explicitly for an order that you resume possession, that nevertheless you have done sufficient to stop time running.
Yes, the time continued to run, and I think we must remember, my lords, that if one delays for so long, and then things have happened in the meantime, as in this case, it is after the appellant was let into possession and began to expend enormous sums of money on this land that these proceedings were brought to set aside the acquisition. And all remedies are discretionary. even under what corresponds to Section 14 in Trinidad in the Constitution. All are discretionary. And the judge is not obliged to make an order for possession. He could make an order for damages, as was sought in this case. He doesn't have to make an order for possession to give redress. He must look at all the circumstances of the case. He must look at what was put to him in the case, what was being asked for, because that is the final chance for the litigant. The litigant must say what it is he wants, and the judge must adjudicate, and all remedies are discretionary. And the remedies take into account what has been going on. The owners of FG&H took nearly 12 years before they challenged this thing. And the law about that, my lords, is this. It's set out, as I put the case in my bundle of authorities, I'd ask my lords to have a look at it. It's the case of the Privy Council judgment in Dunlop and Woollahra Municipal Council, which is at tab 7 of my bundle. And in that case, their lordships were dealing with an invalid council resolution relating to property. And this is what was said. At page 702, the last 4 lines. The effect of the failure is to render the exercise of the power void, and the person complaining of the failure is in as good a position as the public authority to know that this is so. It's the same here. They knew that it was so, or they thought it was so. But they took 12 years before they launched an action to set it aside. And that goes for the first and second respondents. They could have ignored the order if they didn't think it was good. And they could have launched their proceedings for possession or asked for possession in the same constitutional motion. In other words, on a constitutional motion, the law would be the same as in Trinidad. The provision is the same. The discretions to give constitutional redress would be the same. And it would include the right to for an order for possession, as well as damages or compensation for the loss of the rights.
But if the court held as it did, that the compulsory acquisition order was ultra vires,
yes,
and void, then surely the court would not have any discretion to refuse an order setting it aside or striking it down. And once it had done that, again, the court would have no option but to make an order, at least if one was sought, for recovery of possession. I mean, the discretion which a court has to give redress for a breach of a constitutional right does not apply in a case where some purported act of the executive or the legislature is ultra vires and void. Does it?
But of course, my lords, in my submission, the court must have a discretion to give damages instead, depending on what circumstances had transpired. In these 12 years, the court would have the right to give damages against the state in this case. Because the state was acting on the basis that the acquisition was lawful when, under the law, the paper owners were supposed to know that the acquisition was not lawful. And that is why the Privy Council said in the Dunlop and Woollahra case that they could ignore the order and proceed. says in the last line, page 702, he can ignore the purported exercise of the power. It is incapable of affecting his legal rights. In agreement with Yeldon, their lordships are of opinion that the claim in negligence fails too. See, they could have just sued for the recovery of possession, and then they could have contested the defense. The defense being that they had no right to possession because the possession was on the basis of lawful acquisition orders, and that they were entitled.
But Sir Fenton does not. The whole basis of your claim that the title of the previous owners has been extinguished by prescription depend on a right to recover possession having accrued to the owners, at least as from the date of the acquisition orders. Now, what you are now submitting, that well, they were not entitled to an order for possession, but it was a matter of discretion as to what relief was granted by the court, would seem to undermine the case that a right of action for possession had accrued.
The right of, yes, but the right of action for possession had accrued from the time the orders were made.
If they had a right of action, then having brought an action, they would be entitled.
The orders were not constitutional and were not valid. So they had a right of action from the time the orders were made.
To possession.
Yes, my lord. Yes.
In fact, Sir
right
Fenton,
of action to recover possession.
well, Sir Fenton, in this respect, could I refer you to the motion of November 1989 in the record at pages 611 and 612. So it's volume 3 of the record of appeal.
What date is it?
Page 611 to 12. It's the November 89 notice of motion brought by the second respondent.
Yes.
And if I direct your attention on page 612,
Yes.
there is a specific claim, I think it's number 4, 1/3 of the way down the page, for a declaration that since the purpose for which the lands were purportedly acquired no longer exists, the applicants, and this is the crucial part, are entitled to have the said land returned to them. So this action shows that where you are alleging the compulsory acquisition orders are void and ineffective to transfer title to the state, you can, in that action, also claim to recover possession of the land. And that's the key point, isn't it? If you've got a right to bring that, then that is a right of action that accrues as soon as you have a claim that the orders are not valid.
They could have claimed possession.
Well, in the November 89 proceeding, the second respondent actually did claim that they're entitled to have the said land returned to them, which I assume means that they're entitled to recover possession of it. If the land is returned to them, they get possession. So they were claiming to recover possession, and they are entitled to do that as soon as they claim the order is not valid.
And there was a consent order made on this.
Determined by consent. That action was not determined by any adjudication. It was determined by an agreement between the state and the paper owner of Area C.
But
behind the back of the appellant.
No, but the state is your predecessor in title.
My point, Sir Fenton, is that the key issue is, does a right of action accrue as soon as to recover possession of the land? Does a right of action to recover possession of the land accrue as soon as you can claim the order is not valid? Yes. And it would seem to me, in theory, you can do that. And it seems to me, in practice, the November 1989 claim of the second respondent actually does claim to recover the land, recover possession of the land. And once one concedes that in theory you can claim to recover possession of the land once an order is valid, then you have a right to recover possession of land that accrues as of that date. And you don't have to wait until the court actually declares that the order was not valid.
Yes, but that depends, my lord, on whether 4 means that they were claiming an order for possession. What I think 4 meant was that they wanted the title to the land returned to them, because the evidence shows that the conveyances in the registry of the court were altered so as to put the title in the name of the state. And what they were asking is that the land be returned to them, meaning that the titles be returned upon them giving back the $70,000 that they had paid, that they had been paid.
Well, we may agree to differ on that.
That's what 4 means. An order for a declaration, an order for possession, my lord, is not put in the relief in that way. An order for possession is an order for possession. Everybody can understand that it's an order for possession, you see. What that number 4 was doing was saying, look, the title has been taken away and we want it back. And we've been paid $70,000 for it, and we would pay back the $70,000. Which was the sum received for the purported acquisition.
Yes. Perhaps we should move on.
It's strange that that motion doesn't ask for damages or compensation for being kept out of the land.
Perhaps we should move on, Sir Fenton. We can agree to differ here.
The crucial issue must be, therefore, whether there was a proceeding to recover possession within the meaning of Section 5 of the Title to Land Limitation Act, to which I would wish to turn.
Yeah. Yes, would you go ahead?
11 of my bundle. Section 5 says, no action shall be brought by any person to recover any land after the expiration of 12 years from the date on which the right of action accrued to him, or if it first accrued to some person through whom he claims to that person. So one has to consider when the right of action accrued, because it can't be brought. But it says no action shall be brought by any person to recover any land after the expiration of 12 years from the date on which the right of action accrued. And where the person, 6 says, where the person bringing an action to recover land or some person through whom he claims has been in possession thereof and has while entitled thereto been dispossessed or discontinued his possession, the right of action shall be deemed to have accrued on the date of the dispossession or discontinuance. These two provisions are dealing with possession. Section 10 is dealing, that's the next page. No right of action to recover land shall be deemed to accrue unless the land is in the possession of some person in whose favor the period of limitation can run. Hereinafter in this section referred to as adverse possession. And we are under the foregoing provisions of this Act. Any such right of action is deemed to accrue on a certain date, and no person is in adverse possession on that date. The right of action shall not be deemed to accrue unless and until adverse possession is taken of the land. In this case, there was the state in possession, and then the possession was continued by the appellant. And at the time the petition was presented in January 1993 for a declaration of title. The joint possession of the state and the appellant had been in excess of 15 years. Yes. So that would be possession by the state and the appellant for the limitation period.
But you are submitting that we should ignore altogether the constitutional motions that were brought by the first 2 respondents, so far as the computation of time is concerned.
The motion by the respondents cannot be ignored because of the result. That is, that the acquisition orders were unconstitutional and bad in law. So they can't be ignored because they have altered, from the appellant's point of view, the whole nature of the transaction in which the appellant entered into when the appellant entered into an agreement of purchase and sale with the state. But assuming that the result of the litigation in respect of parcels F, G, and H was binding, then what it meant was that the authority by which the state was in possession was not a lawful authority, but the state was still in possession, and the appellant after the state was still in possession. So the question is whether there was an action for the recovery of possession of this land within the 12-year limitation period. And my submission is that no action for possession was brought, that the claim of the owners of F, G, and H was that they should get damages and costs and a declaration that the acquisition was bad. They got the declaration that the acquisition was bad, and they got their costs, but they weren't awarded any damages. They had not asked for possession. In relation to the parcel C, but of course, my Lords have heard my submission on the meaning of relief 4, which was sought on the motion in relation to parcel C. Parcel C was complicated because the state had paid compensation. The title had been passed over to the state on payment of compensation, and the motion was intended to get the land back from the state. They wanted the title back. And by the consent order, they got the title back. But the consent order did not have anything in it about possession. One would have expected that if that consent order was to deal with possession, it would have been said in the order that possession must be returned and a date fixed for possession to be returned, or forthwith. But no such thing happened. And so that is the injustice which has been done to the appellant. The appellant has not been a party to these proceedings, even though the appellant was in possession. And no claim for possession was made in the proceedings. The applicants would have known that the appellants were in possession. And they wanted a declaration that they had the titles, and they wanted a declaration where they wanted an award of damages and costs. Or they wanted, in the case of Parcel C, they wanted the parcel returned to them. But that is as far as it went. And one can see from the consent order that was made in relation to the action by the owner of Parcel C, what that said. And I refer my lords to the order in the supplementary bundle, page 21 of the supplementary bundle.
Sir Fenton, could I refer you to page 22 of that supplementary bundle?
Yes, I have it before me, please.
Where it says, and by consent, it is further declared that the applicants are entitled to have title to the property restored and registered in their name by the Registrar of Deeds.
Yes.
Now, it doesn't expressly state they should recover possession, but is that not the necessary implication? If someone has title restored to them, then automatically, since it's their title, they must be entitled to possession of their land in that title.
Yes, but that order was being made by consent in 1995, and true, it is made on a motion that was filed in 1989 November, but the clear meaning of that part of the order is that the applicants are entitled to have the title to the property restored and registered in their names, because the title was deregistered. The state got the registration of title in this case. And what that order is saying is that the title must be altered back to the owner of C. But it has nothing to do with possession. If they wanted an order for possession, it would have been stated in there. But it cannot be that this order can be read without doing the gravest injustice to the appellants.
But what is the point?
Order for possession.
What is the point, Sir Fenton, of getting an order for the restoration of the title to you if you don't intend that to resume possession, and you are not going to be in a position to transmit possession to anyone else? What then you are separating the ownership of the land from the possession of it, and all you are holding is a very hollow, empty paper title. What use is that to anyone?
If they got the paper title and time had not run, they would of course be entitled to sue to recover for possession, because they would have been within the 12 years. But if they didn't sue for possession within the 12 years, the statute was running, and none of the parties to this consent order had been engaged in a proceeding for possession. This motion of 1989 1989, 14th of November, in relation to Parcel C, was like the one before it, aimed at setting aside the acquisition and having a retransfer of the title. But meanwhile, the statute of limitation was running. And when this order was made by consent in 1995, the petition for a declaration of title, which was filed in 1993, was before the very court. So it must have occurred to somebody that possession would be needed. Here you have people in court, in the same court, saying, look, we are entitled to a declaration of title. And this proceeding is going on, and a consent order is being made, and not a word about possession. And everybody knew that there was pending in the court at that time the petition for declaration of title in these proceedings. It is strange.
But Sir Fenton, perhaps they thought it was obvious that possession ought to follow that order, in that the whole point about bringing the proceedings in March and then November 89 surely was to get the order declared null and void so that title would be restored to the first and second respondents so they'd recover possession. The whole point would be pointless, really, if they didn't, in the end of the day, get back their possession of the land. And perhaps they just thought it was so obvious you don't need to spell that out when you actually have the title restored to you, particularly when the orders are declared null and void and of no legal effect. But again, perhaps you may differ on that interpretation.
Anyway, Sir Fenton, I think we should move on. We are grateful to you for drawing our attention to the fact that possession is not expressly made the subject either of the motion or of the orders. And we'll have to consider what the effect of that is.
Much obliged.
Yes, but let's move on now, shall we?
Sir Fenton, if I may ask you a question, how would you define title?
I think the title refers to the transport. That the title refers to the paper title. It refers to the title which is registered in the deeds registry, a title which in the law of Guyana has to be passed before the court. It has to be passed coram lege loci, after due advertisement. So the title there means the registered title passed by the court itself.
Yes, sir, but isn't it some sort of evidence, documentary evidence, that you own land?
It is a documentary title.
It is a documentary evidence of ownership of land?
Oh, yes.
Sir Fenton?
Oh, yes. It has to be.
Well,
It's
if it
title
is.
to the land. It's evidence of ownership of the
So ownership involves possession.
Oh, ownership
Doesn't
involves
it?
the right to possession. It doesn't involve possession. A person can be an owner without being in possession. Ownership involves the right to possession.
Indeed,
But it
indeed.
doesn't involve possession. Somebody else could be in possession.
Yes, indeed.
At any rate, if you take the commencement of the period of limitation as being the 28th of March, 1977, then it would appear that 12 years would have run before the second respondent instituted the INSAC or her constitutional motion to challenge the acquisition.
Well, yeah. Well, when we are counting in relation to the second respondent, that's Area C.
Yes.
The title was gained early in 1976, and they became entitled to possession by virtue of that ownership early in 1976. By 1988, that title would have been extinguished in my submission, without a doubt.
Yeah, but there was no evidence, was there? Certainly no finding that anyone, that the state was in adverse possession of Area C prior to the acquisition orders. But there is a fundamental aspect of this case on which I would wish to have your assistance before you complete. And it is this: assuming that you succeed in persuading us that the title of the previous owners in relation to certain parts, at any rate, if not the whole of this Turkian estate, has been extinguished, assuming that the prescriptive period has run against those from whom the land was compulsorily acquired by the state. How do we resolve the competition between the state and the appellant?
Well, so far as the state is concerned, Lord, the state put the appellant in possession of all the parcels. And as it turns out, that the judge's judgment, as confirmed by the Court of Appeal, meant that title did not vest in the state in any of the parcels. That was the whole finding of May 1990 by Justice Kissour. So that those parcels about which no opposition was entered remained parcels against which the appellant could prescribe. There was no opposition in relation to those. So that in my submission, the appellant was entitled to succeed in relation to those parcels because of the judgment which said that the acquisition did not vest title in the state. So the 12-year period of the sale took place on the assumption that the title had vested in the state. But as it turned out, by the judgment of 1990, confirmed by the Court of Appeal in 1995, the vesting was not effectual. There was no effectual vesting of any of the titles. There was opposition in relation to C, F, G, and H, but not in relation to the others. And there was no reason whatsoever why the appellant should not have succeeded in relation to those other parcels of which it was in possession, because those parcels never vested in the state, but the...
Well, but you are ignoring something.
Yes.
The state was in possession of this land before the appellant, and it is the state who put the appellant into possession. It turns out that the state never had any paper title to pass. But on the assumption that I have made, it would transpire that there was a title by prescription, which, as between the first possessor and the second, would ordinarily go to the first possessor, that is the state. Now, the appellant has not, or had not, by the time when these proceedings were launched, had not acquired a prescriptive title against the state. And the rights of the appellant as against the state are really grounded in the agreement for sale.
Well, the agreement for sale in the law of Guyana put him in adverse possession.
How could it put him in adverse possession?
That appears from two judgments before your lordships.
But assuming that is so, by 1993, and indeed, even by 2008, the 30-year period which is required to acquire state land by prescription would not have run. Even the 12-year period would not have run in 1993.
But this is the way I look at that, my lords. For purposes of this proceeding, purely as a result of the nullification of the orders, the appellant was in possession of private land, which the state purported to sell him on the basis that the state had owned it. But it turned out that the state did not own it. So when he was put into possession, of private land, and he was prescribing against the owners of the private land. That is the way I look at it. Because the state did not have the ownership which it was proposing to sell him, and in respect of which it took 1/3 of the purchase money, with the right to the remainder on passing of the conveyance. That's what the agreement said. But that was torpedoed by the judgment of May 1990, because by that judgment, the state could not even pass the title now. That judgment put the state out of the ownership, so that the only ownership that would remain would be the ownership of the private owners of all the parcels.
But is not the state's title to the land, would that not be fed by a favorable judgment from this court? I mean, would it not seem odd that the appellant should have a windfall and get the 82 acres for 1/3 of the price which it had agreed to pay, because the title it was getting was not a paper title, but one which arose by prescription. I mean, whatever the nature of the title, the state is the predecessor in title of the appellant. It is the state who was transferred whatever right and interest it had, or agreed to transfer whatever right and interest it had to the appellant. But it agreed to do so for a price.
Yeah, there was an agreement that the state would take 1/3 of the purchase money that the purchaser, the appellant, would conform to certain conditions set out in the agreement, and that upon passing of the conveyance, the remainder would be paid. But the state cannot, unless it were to put itself in order, simply pass that conveyance. So it is not that the appellant is getting a windfall. This is not of the appellant's doing. This is not of the appellant's doing at all. The appellant paid his money.
But isn't that why it's so involved?
No, my lord, it can't be a windfall. Because the appellant paid his money, went into possession.
Paid 1/3.
Yeah, but he began to expend enormous sums of money, 22 million on the land. He has no windfall to get. All he will get out of this is a loss.
But, Sir Fenton, let's just look at it in simple terms. This is Area C we're discussing, where let's assume that the state had adverse possession for 11 years, up to 1988, and then from 88 to 93, your clients, the appellants, had 5 years adverse possession. So your 11 and 5 makes 16 years, or if we're a little more, at least there was 12 years in before the 89 period. So let's just assume, though, to keep things simple, there's an 11-year period plus, say, a 2-year period to take you over the 12 years. So that's enough to extinguish the title of the second respondents. The question then, what happens? Do we have a black hole? Because the state can say to your appellants, look here, we were in adverse possession for 11 years, you've just come along for a couple of years, our right to possession is prior to yours, it's superior to yours, and therefore we're entitled to the land and to evict you from possession of the land, because you can only adversely possess against whatever title we may have if you get 30 years in, and you clearly haven't. So as between the state and your appellants, the state is entitled to possession of the land, not your clients.
But the state can't claim that it had title to the land because of the nullification of the acquisition order.
It had possessory rights. It had 11 years' worth of possessory rights. We're not saying it had title. We're saying it had 11 years' worth of possessory rights, to which were added a couple of years of the appellant. Why should the appellant get the whole land when we extinguish the second respondent's title? Surely the state can say to the appellant, we had a right to possession for 11 years, you've tagged a couple of years onto us, title is based on relativity of rights to possession, our right to possession is superior to yours, you can't get any rights against us for 30 years, therefore we have a right to possession and you can't have any entitlement to possession.
I don't follow the argument. I don't follow the argument.
At any rate, Sir Fenton, your time is running out, so I think we should let you go ahead without further interruption.
Now, if, my lords, if we understand that the effect of the nullification was that the state does not have the paper title anymore, as it thought it had under the acquisition orders, then if the state had got 11 years, the state was intending to pass over those 11-year rights when it sold. Must be presumed to be so, because although the state was thinking that it owned the land, it didn't really own it, but it meant to pass over to the appellant whatever rights it had.
Well, is that right? Didn't it contract to transfer the title by transport on the basis it had legal title, so there could be a transport? But in the absence of legal title, you can't have a transport, so arguably it takes away the whole substratum of the contract, unless you can construe it in this broader sense of saying, well, you must fall back on saying it's the whole interest or such other lesser interest as the vendor may have.
Well, I can understand that, my lord. I can understand that.
Yeah.
I could understand that. I could understand the argument now.
Right.
Because it seems as if the intention as between the state and the appellant was that the appellant should be able to have the title and that the state should have all the money. And if it should transpire that the whole thing cannot come about, then there must be a proportionality about it and a proportionality of remedies.
Well, that's another problem, that if the title can be conveyed only in respect of part of the land, how do you divide up the agreement for sale? How do you allocate the purchase price and so on?
But that would be done by agreement, or it would be done by an inquiry, which the court will order if the court came to that.
Well, I certainly think agreement would be preferable.
Well, you know, my lords, when it comes to land in Guyana, landowners seek to protect their own interests to the hilt. And if there is no agreement, there is always a way in which the court could make a decision by using its own machinery to settle disputes. That's what the court is there for. The court can always settle disputes. If the parties wish to agree, well, then it does them good. It's in their own interest to try to agree.
But after 30 years, it's time that it be settled one way or the other.
Well, this shows that this whole case shows how ineffectual the whole legal system has been. That's all it proves. But justice has to be done somehow.
That's where we
head of the judicial affairs of Guyana now, and justice has to be done somehow. Something has to be worked out to do justice to parties.
And that hopefully is where we come in.
Yes. Guyana didn't have a third court. It was taken away and nothing to replace it until now.
Yes. The other aspect of the matter, which has caused me some concern, is the fact that we are being asked to make an order which will exclude from their paper title persons who are not before the court. That is the owners of the areas K, J, and No.
Yes.
And I'm a little concerned that they have never been privy to these proceedings. And I don't know quite what their status is, or whether they have ever given any indication of their position. It appears that they have not made any effort to play any role in the court proceedings.
Well, the titles may have changed considerably over the 30 years. In 1976, there was a nationalization of the sugar lands, and a lot of this land is now claimed by private limited liability companies run by the state.
I think the point, Sir Fenton, is we know who the three owners were of JKNO, and they were paid compensation for their lands being compulsory acquired.
They were not paid.
No, they're not, because there's an allegation somewhere that there were.
No money was voted for this acquisition. That's what the judge was told and what he found in his judgment, Kisoon, in 1990. No money was paid. The parcel C was the only parcel in respect to which 70,000 was paid. Up to the time when the owner of F, G, and H brought proceedings, no money had been paid.
Well, that makes the position worse then for the owners of JKNO, because if they weren't even paid to lose their title, so to speak, then it's a little tricky for us to decide adversely against them when they don't know what's going on. On the face of it, you can say, well, good heavens, 31 years have elapsed. They must be taken to have waived their rights and acquiesced in whatever's gone on. On the other hand, if we actually look at Section 4 of the Title to Land Prescription and Limitation Act, which empowers the court to make a declaration of title in regard to land, it says that it must be one in which all the parties interested therein are before the court. And we don't actually have those three parties who lost their lands JKNO before the court.
Yes, but that provision means that the parties who had an opportunity to come before the court but didn't come. We must remember that the petition has to be advertised to the world, and that when the English law rule that if somebody is on your land, you should be able to inquire what they're doing there, applies in Guyana as well. The hunt and luck rule applies there. If they for 30 years didn't take any action, and we don't know what they did, we don't know what was going on, because as far as the litigation here is concerned, it was really confined to parties representing C, F, G, and H.
Yes. So we should say, you would submit that we shouldn't be overcautious here, but in the interest of doing justice in relation to Guyanese land, we should be bold.
What we should be doing is remembering that over 30 years, if there were somebody interested in getting money for the land, K, N, J, and O, they would have come forward and we would have had proceedings in the court.
But the acquisition not having been declared invalid
Yes.
in relation to JKNO,
Yes.
Is there any question of adverse possession here? The
There must
title
be
of
adverse
the
possession because they were out of possession and the state and the appellant were in possession.
well, I mean, on the face of it, the state is in possession under the acquisition orders,
Yes.
which on the basis of their presumptive validity, notwithstanding the decisions in the other two cases, and subject to the doctrine of precedent, the effect of it. You know, the acquisition orders in relation to those areas has not been struck down, and on the face of it, in the land registry, the annotation, presumably showing that the lands have been compulsorily acquired by the state, remains on record, doesn't it?
The compulsory acquisition by the state was not expressly set aside in relation to the other parcels, but because they were not brought into the proceedings. But the ruling that no compensation was paid, and therefore the act was not satisfied, that the title could not vest, remains. It remains for all the parcels. And
Well, I
in
don't
relation to
know.
C, the money was returned.
I don't know whether there's evidence about what happened in relation to JK and O.
There was no evidence that compensation was paid in relation to those parcels. The evidence is that compensation was not paid for any parcel. So K and J and O at the time would have remained where it was in 1977. And we know the names of the people who own K, N, J, and O. The Chief Justice set them out in his judgment. Changwi, Guyana Housing Corporation, East Coast Estates, and so on. The Chief Justice put the names of those people in his judgment. So there were people, but nobody sought to take any action as far as we know.
But
While we were in possession and we were developing the land, if the appellant went onto the land and began to expend money for development for a housing estate or housing complex or what, the owners of the land should be knowing if they felt that they had any rights which they wished to enforce. Why would they not take action after all these years? We can't presume that they care now.
yes, but what I'm asking is in relation to a JK and an O. What's your remedy really to seek a declaration under the Title to Land Act, or was it simply to enforce the contract for sale?
Well, the truth about that is that the court has both things before. The court has all the facts of the case. So it's either one or the other.
Well, I don't know about that.
But
I
the
noticed
petition-
that the Attorney General in his written submission claims that he has cancelled the agreement of sale. I haven't seen it.
So the Attorney General's position there is that he has cancelled the agreement of sale. I say he has repudiated the agreement of sale. He is not now in a position to rely on it if he is repudiating it or has repudiated it. We didn't repudiate the agreement. The Attorney General, for the first time in a submission in these proceedings, says he cancelled the agreement. Never said so in the court below, at the trial or anywhere else. This is the first time this is being said on the issue 6 in his submission in these proceedings. But be that as it may, what does the Attorney General get out of that? If he says that he cancelled the agreement, it puts his position no higher, because having regard to the nullification orders, he had nothing really to sell, not by way of title. He could have sold and given us possession, which he did. He gave us possession, but he couldn't do any more than that. And we're still in possession. He hasn't sued us to take it back. He hasn't sued us to take it back. And where will he get with that if he tried to take it back? He performed
If he had,
to the letter.
Maybe it's to simplify it. Let us assume that the agreement for sale was limited to JK and an O. If he had, there was nothing to prevent him from passing a transport to you of those lands, and the land registry would have been bound to give effect to that, to enter it and register it. And you would have a title that you could not only give you possession, but you could transmit. Isn't that so?
Yes, if he had something to convey to us, he could convey it.
No, not if. As things stand, there is his title to those areas has not been disturbed.
Lord, I think we should ask the first question first. Was the title to those areas vested in the state?
Yes.
The acquisition orders under which they were supposed to vest were not enough. They had, Section 7 of the Acquisition for Public Purposes Act says that unless the compensation is voted or agreed by the Assembly, National Assembly, the title does not vest. And we know from the judgment of Kisul that no compensation was paid or agreed to be paid. Indeed, the counsel for the state told the judge that there was no need to vote for the Assembly to vote any money. So where does that get us? It gets us in this position, that the state did not succeed in getting the title vested by what it did on that occasion. It doesn't follow that the state can't take steps to get in the titles.
But, Sir Fenton, wasn't there a time in 1992 when they advertised the transport?
But didn't go to pass it.
But apparently your client went armed with his check, acknowledging that the state could have passed an executed transport.
Yes,
so
but they didn't come to pass it, so the check wasn't handed over.
So did he not take it that the state was entitled at that time to convey the property to him?
He thought so. He was acting on the basis that the state was entitled to do so. And he took his money there. Transport was advertised to be passed before the court, and he took his money. But he never got the title. But the appellant was not at fault. The appellant did what he could under the agreement. But he was met by the nullification orders and the attitude of the state. Obviously, the state changed its mind about honoring the agreement. So the state now says it cancelled it. That may explain why the state did not go to pass the transport after it was advertised in relation to KNJ and O. The state must have thought that he could do that.
But, Sir Fenton, we can't really go into the rights and wrongs of the contract, I think, because we don't have enough information before us and no proper pleadings to determine whether there should be an action for damages for breach of contract or an action for specific performance of the contract or anything like that. All we can deal with really are these prescriptive claims today.
Yes, it's the petition that is on.
You see, what we are in a position to decide, as my brother has said, is whether or not the title of the first and second respondents has been extinguished. Now, even assuming that we find that their title has not been extinguished, there still remains the case of areas K, J, N, and O, and in respect of which we have a claim from you to a declaration of prescriptive title. I tried to explain the difficulties which that raises, given that you don't have a good prescriptive title against the state. So the point that I am making is that particularly in the light of the long history of this litigation, that it would be, I think, a great achievement if the appellant and the state, through their respective counsel, could come to some agreement, firstly, as to how the land JKN and O should be disposed of. And secondly, if either of the other two tracts, those that were owned by the first and second respondents, if we hold that the prescriptive title has been established to them, or that the first and second respondents' paper title has been extinguished, similarly, how those lands should be dealt with as between the state and the appellant. Yes, would you like to wrap up now, Sir Fenton?
Yes. Is there anything more my lords would like to ask?
Anything else?
Documentary evidence.
Sir Fenton.
No, my lords.
Sir Fenton. I'm here. My question is, you were about to say I have two authorities for my submission that my client is in adverse possession after it had gotten possession from the state. But I didn't hear the two authorities.
Yes. The authorities are Gonchi and Horrell. Gonchi and Horrell is a tab 8, I think, of the tab 8 of the second respondent's bundle. And Ramlakan and Farouk, which is at pages, no, Gonchi and Horrell is 1931 to 7, Law Reports BG, LRBG, page 509, a judgment of Justice Verity, tab 8 of the respondent's bundle. That case says that where an agreement of purchase and sale is made in Guyana, the purchaser goes into adverse possession against the vendor when he takes possession. That case was followed by Ramlakan and Farouk, R-A-M-L-A-K-H-A-N and Farouk, 1974, 21 West Indian Reports 224. And that is in volume 2. It's recited in volume 2 of the record at pages 48 to 50. The Gonchi and Horrell was followed in that case. And repeated that where there is an agreement of vendor and purchaser, and the purchaser enters into possession, he enters into adverse possession against his vendor. There is no question like
just a minute, please.
Saying he may be a tenant at will or something.
Would you just hold a minute? Yes, I'm sorry. Go ahead, please.
Those two cases, Ramlakan and Farouk, 1974, 21 West Indian Reports 224, at pages 48 to 50 of the record. Second, it's in volume 1, page 48 to 50. Those cases show that the High Court, the Federal Supreme Court, and the Guyana Court of Appeal, when it was a final court, had ruled that a purchaser going into possession, whether he paid only a part of the purchase price or all of it, was in adverse possession to the Federal Supreme Court, Court of Appeal in 1974 in Guyana, Justice Verity in 1931 to 37 report. Those are the two cases I wish to.
Yes, well, thank you, Sir Fenton. You will have an opportunity to reply, and if you have any further thoughts on the matters which we have raised, you can give us the benefit of them at that time. Thank you very much.
For clarification, sir, of something I said earlier. The paper title is documentary evidence of ownership. Ownership is the totality of rights the state permits a person to exercise in relation to a thing. And I shall hope that that clarification be understood.
Lord, I'm not sure I understood what my Lord is asking.
I'm saying that ownership is the totality of rights the state permits a person to exercise in relation to a thing, including land. It's just a clarification I'm making.
Yes. Well, I think Mr. Chase will be next. And unless there has been some agreement between the respondents as to the division of the 90 minutes allocated to them, we will give each respondent 30 minutes.
May it please your Honours, thank you very much for the opportunity to address you on the first named respondents' points touching this appeal, and I will try my utmost to keep within the time frame that you have given. I propose to start by considering and inviting Your Honours to consider what is entailed in adverse possession, which I think is one of the key issues in these proceedings. Our submission is that the state was never in adverse possession of the properties owned by the respondent, the first named respondent. That statement is, of course, premised on two things. First, on the acquisition orders number 22 of 1977, and more particularly number 43 of 1977. And secondly, on the alleged acquisition and alleged annexation of the state, in inverted commas, adverse possession, adding that to the alleged adverse possession of the appellant. So far as the orders are concerned, your orders will see them at number 17 of the bundle of cases and authorities submitted by the first named respondent. And so far as the tacking on of the state, again in inverted commas, adverse possession to that of the appellant, That can be seen on pages 513 and 514 of the record. Your Honor, in relation to the acquisition orders, these were made under the Acquisition of Land for Public Purposes Act, Chapter 62:05 of the laws of Guyana. And I particularly wish to invite Your Honor's attention to the procedure that is laid down in that act for the government to acquire land for public purposes. There is a procedure laid down which we respectfully submit they should follow. After that procedure is followed, Section 8.2 of that act, Section 8.2 of that act prohibits the owner of the transport for that land from mortgaging the land, from entering into any contract in relation to it, or taking any act touching that transport. Section 8.2. That Section 8.2 was translated into general language by the state itself to the Ministry of Works when they wrote 2 letters to the first name respondent. Those letters are set out at page 573 and 575 of the court's records. And those letters were served on the first name respondent. And in serving them on the first name respondent, the permanent secretary was saying to them, look, we are entitled under the law and you are not to touch this land or the transport or mortgage it or do anything after it is vested in the state. So that our respectful submission is that when that order was made, the order was made under Section 6 of the same Act, when the order was made taking over the land, its consequences are followed under Section 8, and the state itself wrote the client to say, please do not touch those lands after vesting. And vesting in our law, with respect, permit me to say, under the old Roman Dutch system, give full and absolute title to the holder of the transport, because he gets his transport by some procedure before a judge or the registrar, if the registrar of deeds, if she's appointed to act, but it's a judicial act in getting transport. And therefore, when those orders were made, the properties in question were vested in the state, and I invite Your Honours to look at one of our transports, which is set out at page 557 of your record. Nowhere in that transport will you see the word possession mentioned. When you get transport, you're absolute owner, you full owner of the particular land in issue. The only thing that can upset it is if there's fraud or if there's some prior statutory claim against you. But in the absence of that, you have full title. And the effect of our title in our law, Your Honours, is set out in Section 22 of Chapter 5:01, the Deeds Registry Act, which you can find at number 14 of the bundle of documents submitted to you by the learned Attorney General. Adverse possession, on the other hand, Your Honours, entitles a person or an individual to openly and uninterruptedly occupy the land of another. The very fact that the state had to give notice to the first name respondents who owned land there, that they had taken it over, that they passed 2 orders, one for surveying the land, 2 for acquiring it, differentiates acquisition of land for public purposes from title to land by prescription. 2 different roads you have to travel to get ownership of land in that respect. And what is set out in Section 10 of the Title to Land Act, the basis of Section 10 and the basis of all of Chapter 60:2 is adverse possession, not just possession, adverse possession. The proprietors, Your Honor, having been served with the notice from the state, the proprietor is expected to respect the law and is debarred from interrupting the occupation and the taking over of the land from the state. This is our view, and we ask you to examine the Act, examine their letter, and we hope you will come to the same conclusion. We submit, therefore, Your Honors, that the owners could not sue, the first name respondents, could not sue the state for possession so long as those orders were extant. They could not sue the state for possession of their land. The submission is really that the acquisition of land for public purposes is qualitatively different from that of acquiring adverse possession. The principle of law is one that no one can give what he does not have, nemo dat quod non habet. And in our respectful submission, if the state did not have adverse possession of the land in question, it couldn't pass it on. That's our position.
Mr. James, may I just ask you a couple questions? On the 20th of March, 1989, the first respondent filed a constitutional motion challenging the validity of the acquisition orders. Is that right? Is that right?
I believe you're probably...
Sorry?
I think so.
Yes. Well, could that action have been brought at any time after the acquisition orders had been made?
The action, it was a motion, constitutional motion to start with, not an action. You couldn't bring any action, I respectfully say.
Well, I don't know.
But there were things that were taking place. Discussions that were going on. There were talks.
No, I am not asking you to explain why they were not brought before. What I'm asking is merely as a question of law, whether that motion could have been brought with equal success at any time after the acquisition orders were made.
Offhand, I would say certainly.
Yes.
That has not been questioned or challenged in any court prior to now.
And would it not have been possible in that motion to seek as part of the consequential relief an order for possession that the state give up possession of the land to the first respondent?
My answer to the first question, Your Honor, having said yes, it depends also on the circumstances of what was taking, of what were taking place, but you don't wish me to go into that, and I wouldn't. In relation to the second question, I wish to emphasize that having made the constitutional challenge, it is not necessary to go on to ask for an order for possession. If the land is yours, it is yours to possess. As I pointed out just now, there is no title, there is no transport in our country that uses the word possession is to be given to you. You have that document. It is an indefeasible title, virtually indefeasible, and it gives you the right to possession. So if you set aside and improper taken away and you get back your title, automatically the possession is yours.
So that the constitutional motion which was filed was a proceeding by which possession was being sought to be recovered by the first respondent. Was it not?
I don't think I quite
I say that since you said that you don't even need to make a specific claim for possession, because that is an incident of ownership, and the motion, the constitutional motion that was filed by the first respondent was a proceeding by which the first respondent was seeking inter alia to recover possession.
That is correct. That is quite correct.
And Mr. Chase, so was the motion on behalf of your client in November 1989, because remember at page 612 I read out before, in paragraph 4, your client sought a declaration that the applicants are entitled to have the said land returned to them as a result of the order being ineffective. So that again clears a situation where in their claim to recover, in their claim to have the order declared null and void and ineffective, they were claiming to recover possession of the land.
That is quite correct too. Thank you very much. We rely upon that. And in this matter, it is strange. The strange thing about this case is that the state itself is not claiming that it had adverse possession to the first name respondent's land. And therefore, the rhetorical question must be, how could the appellant contend that it has acquired that adverse possession from the state?
Well, the state might be wrong. That has happened before.
But also, Mr. Chase, haven't you just conceded that this action brought in November 1989 was an action to recover possession of the land, where it sought to have the compulsory acquisition order declared ineffective? Surely that could have been brought much earlier. It could have been brought back in June or July 1977, and yet it wasn't. So more than 12 years have elapsed.
No, more than 12 years didn't elapse from the time of... we've got it in our written submissions, and I will later on, I can't find it now, but I will later on direct your attention. Before 12 years elapsed from the date in June when the final order was made in 1977. We came within 12 years of that, but my respectful submission is that that question of 12 years operation is in relation to a different act, not the question of acquisition of land. The reason why, and His Lordship, the President, didn't want me to go into the reason, I still would not, because it would be trapped from my time. There were reasons why proceedings were not brought in the court. The government position, discussions, and the letters from the peers, and other things. There were reasons, but we got there in time nevertheless, and the order, the acquisition was set aside. Now, Your Honours, in claiming to get the adverse title which the government had transferred to the fellows, The appellant is saying that this was done through an agreement of sale into which the two parties entered. Your Honor, the agreement of sale is set out at pages 518 to 520 of the court record. It was made in October 1987. The first thing I wish to say about this agreement, Your Honor, is that it was only an agreement to purchase. It was only an agreement to purchase, not the purchase and acquisition of the property set out in the agreement itself. And I wish to make 5 points on that agreement. I will state them in the beginning, and then I will just add a few sentences to develop them later. The first is that no payment is recorded in the agreement on account of the acquisition of the vendor's alleged term of adverse possession. Nothing is recorded in that agreement to show that they paid for that. Secondly, it is undisputed that only a payment of $739,033 has been made by the appellant on account of the purchase price of $2.2 million for the property. Thirdly, title and/or transport was never passed to the appellant. Fourthly, the appellant is in breach of that agreement. And finally, the appellant has taken no steps to enforce that agreement, assuming it could have been enforced. Now, Your Honor, in respect to the first point, at the time when this property was being sold, the state was firmly of the view that they owned it, and therefore it could not have put in anything in it to say it was selling its adverse possession to them. So that term couldn't be in there at all. Secondly, the peculiar and probably unprecedented result of the appellant becoming owner of the property described in the schedule by the payment of one-third, it is said this morning, one-third of the amount. Because if a declaration were made in the appellant's favor, there is no obligation to pay any further sum, so they will get the whole property for the payment of the quarter. And conjoined with that, if the declaration is granted, there is no need for the state to pass any transport to them, or to the appellant for the property. The declaration itself will embody the granting through prescription of title to the appellant. In regard to the agreement itself, which I said is at page 518, Clause 7, Clause 8, and Clause 9. Those three clauses are clearly clauses that have been violated and can be rectified because the 3 years limit stated in them, 3 years limit has passed. Under the fifth ground that I mentioned, Your Honor, the question of going to court with a check to pay for some part of this land, if true, and I like to put as much emphasis as I can in the words, if true, doesn't help the appellant because could have applied, as was said in the course of the previous presentation, an order could have been applied for specific performance of that agreement if it could have been enforced. And when we apply at home for an order for specific performance, an order is made that the defendant must pass the property within a specific time. And the order goes on to say, if it isn't passed by the transport owner within that time, the registrar is empowered to do so on behalf of the vendor on, if there's a balance, on a balance of money being lodged with him or her. So that it's no excuse saying you're going to check and didn't get it. The lawyer as well as the appellant must be aware that they could have gone, and if they could have enforced the agreement, claim specific performance of the agreement. Your Honor, there is an alternative contention which was touched upon in the course of the presentation this morning, that a purchaser in a similar position, if put in possession of the land, becomes one of two things: either a tenant at will or a licensee. Pay some money on a concrete property, you put in possession, and you become one or other of those two things. Your Honor, the number 2 respondents have at page 28 of their presentation addressed this point and put up cases which we rely on. And in order to curtail my time, I do not propose to go into it, but I say that we certainly support the proposition that even if those terms could be attached in this case, the authorities are that that does not give you the right to have adverse possession if you're a tenant at will or if you're a licensee. The occupation and your possession does not give you the right to go on to claim adverse possession, and we will rely upon the cases.
But Mr. Chase, if the state was in adverse possession and they put in a tenant or licensee, then wouldn't the adverse possession of the state as against the former owner or the true owner, would that not continue?
I will deal with that point immediately. That's the point I'm dealing with now. Your Honor, this is the contention of the appellant, that the moment those orders were struck down, the moment the acquisition orders were struck down by the courts as being barred in law, the state from 1977 became in adverse possession. That is the contention. I treated it immediately.
Would you just repeat that?
The contention has been that the moment the acquisition orders were struck down, the state was entitled to claim that it was in adverse possession.
As from?
1977, from when the orders were made.
I see.
Appellant's contention. I wish to point out, Your Honor, that there's a difference between, I think I said it before, forgive me if I'm repeating myself, a difference between possession and adverse possession. Being in possession doesn't mean that you are in adverse possession. In other words, Your Honor, what the appellants are saying is that on the nullification of orders number 22 and 43 of 77, a new and different intention is ascribed to the state, and it has to be ascribed retroactively.
Mr. Chase, this is important. I would like to again get it clear. What I understood you to have said and to have repeated is that once the acquisition orders were struck down, the state was entitled to claim that it was in adverse possession. Sorry?
Not the state is entitled to claim. The appellant is saying that the state was. Not the state isn't claiming that. The state isn't claiming that it was in adverse possession. It's the appellant who's claiming that. The state is not saying they were in adverse possession.
No, but I'm interested in what you were saying.
Yes.
And as I was saying, when you stopped me, I was seeking to repeat what you had said. And I just wanted to make sure that I had got it right. And I understood you to say that from the time the acquisition orders were struck down, the state was in a position to claim that it had been in adverse possession of the land from the time the acquisition orders were made. Am I right?
Not that the state is claiming that, so that the appellant...
Just a minute. You go ahead, you tell me.
Not that the state is claiming that the appellants are claiming, that the appellant is claiming that. The appellant, if you just change the word state and put appellant is claiming that, you and I would be ad idem.
I am not interested in what anyone else is saying. I am interested in what... Just a minute, Mr. Chase. We can't both talk at the same time.
My apologies.
I am interested in knowing what your submission is. And I thought that what I had now said about 3 times was what you were submitting. I may be wrong. But go ahead.
I am saying that the state cannot and was not in adverse possession of the land in issue, even though the orders were struck down. They cannot relate back and say,
I see.
The orders were made and were struck down. We are in adverse possession.
And,
you see,
Mr. Chase, I'm here.
Sorry.
Is it then that you are saying that from the time the acquisition orders were nullified by Justice Kizon's order, from that time on the state might have been in adverse possession, or even that?
Post that if they stayed.
Post that.
Post that if they stayed on.
But not retroactively.
You don't expect a decent state to do that. You told you're lawfully in somebody's place. Any decent and well-organized state will move on.
Well, apart from decency, just the legal point. Is it possible for the state, if they would stay in possession after that order, that from that time on,
yes,
they might be in adverse possession, but not before?
I agree.
That is what your point is?
Yes, sir.
Okay.
Let me just clarify. Is that the 1990 order against the first respondents or the 1995 order against your clients?
He's the first respondent.
Sorry. I'm right. 1990 is right. The point I just want to clarify here is that earlier you conceded that a right of action accrued as soon as the compulsory acquisition orders were made, when they were ultra vires and ineffective, as was subsequently decided. You said that the fact that you can, in that action, not just ask for a declaration the orders are ineffective, but can bring an action to claim title to the land and recover possession of the land, shows that a right of action accrues straight away, which was back in 1977. But you're now saying that the right of action can't actually accrue until the order was made in 1990.
No, I don't think we added them on this at all. Your Honor, Justice Kizon's order was made in 1990.
Yeah.
He struck down the acquisition order. When he did so, that land automatically, in our submission, reverted to the original transport owners. It is being submitted not by us, by the appellant, that look, from the time the order was struck down, the orders were struck down, you can go back to 1977 and say that the state was in adverse possession. No, you can't retroactively. back into that position. You were selling the land at the time. When you thought you were the owner, you were in the chair of owner. There's no question of adverse possession in that.
Yet back in 1977, there was a right to bring an action claiming the order was void and the land belonged to the first respondent, and the first respondent should recover possession. That was what you conceded, I thought, 15 minutes ago. That a right of action could have been brought in June 1977 when the invalid orders were made, and that would have covered a right to recover possession.
Not immediately in June. When you look at Section 8.2 of the Acquisition Act, you see that you're prohibited from doing things in relation to that land. My respectful submission, that Section 8.2 of the Act prohibited the owners from going to make any immediate challenge. They couldn't challenge that. That's the law. What they did is go a different route and look at the Constitution and say that, look, these things, or this acquisition was not constitutionally. What is it?
Isn't the Constitution part of the law? You see, Mr. Chase, on one view of the matter, whether possession is adverse or not depends simply on whether there is some other person to whom has accrued a right to claim possession of the land. You follow? So that from the time there accrued to your client a right to claim possession of the land, the possession of the estate of that land became adverse. I'm putting forward that as one possible interpretation of the law.
The possession of the state under the acquisition orders is possession through the law that gives them ownership, title to that land. There is no element or intention of adverse possession when you acquire something by compulsion of law. What is sought to be done is to say that if the order is struck down as being barred, that retroactively you can say that when going back, when you make that order, you had the intention of adversely occupying that land. That cannot be so, because when you acquired it under an order of compulsory acquisition. You took it as owner. You were owner. You can't be owner and prescribe against yourself. What was later done, it was found that what the state was doing was an illegality. And you can't turn an illegality into legality and say, look, you're illegally there, taking up the benefits of adverse possession.
Well, let me ask you another case, hypothetical case. Assuming a transport which was passed was subsequently challenged on the basis that the person conveying was mentally incapable, was insane. Yes, and that was established, so that presumably on that basis the transport would be set aside. Now, what would have been the possession of the purchaser who had entered under the by virtue of that transport? Would that possession not have been adverse?
If the foundation of the sale, substratum of the sale went, Your Honors, he can turn around and sue the person for that breach. But you cannot say that he's in adverse possession.
You can't.
No.
May I ask one other question? You said the constitutional motion was filed within 12 years after the acquisition order was issued, correct? But if I understand you well, you are saying, well, I could have filed the motion even 15 years later, because if the result would be the same as now, namely that the acquisition order was null and void, and the state would still stay in possession, I would have another 12 years to get the state off. Is that correct?
But the reality is that it hasn't been bought 15 or 16 years after. That is out.
Yes.
It was not brought before because of circumstances which we have not gone into in any previous court affecting, relating to the government and other matters. And I don't think we need to.
No, but you are saying you are not limited by the 12 years to file the constitutional motion. And if that motion is filed after 15 years in a hypothetical case, and you would get 5 years later, you would get the decision, yes, 20 years ago that acquisition order was null and void, you would still have 12 years if the state would stay in possession to get them out of possession. That is more or less what you're saying, isn't it?
If an order is barred and declared barred, whenever it's declared barred, it was barred ab initio. And once it's barred ab initio, the consequences follow. Unless you can point to something that introduces a limitation. You see, that Acquisition Act is entirely different from the one in which you have the trial period for prescriptive citation. The Limitation Act is not, the two aren't together, it's two different acts.
Yes.
I understand.
But if we are related to this case and take the situation of the owners of the areas J, K, N, and O, on your submission, they could even now bring a successful motion to set aside the acquisition orders as against them. Yes?
Yes, unless a court said to them, you're coming too late. Unless a court says to them, why are you coming too late?
Well,
opposite side challenges it on some.
Well, is there a limitation period or?
The other side should challenge it on some ground of delay. They did. That's a different matter.
Well, I don't know if you are conceding. I thought you had said that there was no limitation period for the bringing of such a motion. And then, of course, they would have another 12 years after the judgment was obtained, within which to get the state or the appellant or whoever off the land.
Your Honor, I would have thought that I would submit you bring a motion within reasonable time, having regard to all the circumstances. That is my position. You could bring that motion within a reasonable time, having regard to all the circumstances.
Yes. All right, well, I'm afraid your time has expired, Mr. Chase. So thank you very much.
Can I submit to you the balance I had to say then in writing?
Well, yes, of course. You may do that.
I didn't calculate that I might have had to be answering, although it's correct that you couldn't. I have no horror with interruption and answer, but I didn't calculate that when I said I was
Yes.
finishing the 30 minutes.
Well, we have given you about 10 or 15 minutes extra.
All right, can do
But,
it.
If you can let us have anything else in writing, then by all means.
You're meeting back, I'll meet back after lunch, Mr. Davis. If you do, I can undertake to wrap up in 10 or 12 minutes.
No, I mean, your time has expired.
Yes, that's what it is. But I said I didn't calculate that I might have had. So we adverted to our questions and answers.
Yes. Well, I'm sorry we took you by surprise. But thank you anyway, and we will take the lunch break now. And we will resume at
20th of March, 89.
1:30.
We're going back to the 20th of March.
At 1:30 with Mr. McKay.
All rise.
Mr. Chase. Yeah, before we took the break, you had indicated that you would have wished an extension of 10 minutes.
Yes.
And, my brothers and I have decided you should have it.
I thank you very much.
Yes, do come to the podium and address us. This is not a precedent, incidentally.
Appreciate that. Thank you very much for your colleagues. I make the point, Your Honors, and move on, that until struck down, every citizen, every individual is in duty bound to respect, obey, and observe the law. Orders 22 and 23 of 1977
43,
have
is
to
that?
be treated.
43, is that, Mr.
43 of 77, thank you very much. Have to be treated as lawfully binding until they were struck down. In fact, my experience, if you go to the court to challenge a law and you're not obeying it, you're not likely to be heard. You expect compliance first until it's struck down. There's an English case, Secretary of State, Trade and Industry against Hoffman and others in 1973, which supports that point of view. I now turn briefly, Your Honor, to the constitutional position. The Constitution, the first point I wish to make under it is that since 1970, Guyana is an independent republic and sovereignty is in the people and not in the crown. The supreme law in Guyana is the Constitution, and we are all bound by Article 8, which states, which prescribes that the Constitution is the supreme law, and if any other law is inconsistent with it, that law, to the extent of its inconsistency, is void. This governs all laws in the Republic made whether before or after the promulgation of the Constitution. The provisions, Your Honors, of Article 142 of the Constitution, which incidentally is a fundamental right possessed by all individuals in Guyana, qualified and delimit, those provisions qualify and delimit the operation of any law touching and concerning property. It unequivocally prescribes that property of any description shall not be compulsorily acquired except under a written law, the making of prompt payment, and of adequate compensation. It follows, therefore, that this is the only method by which compulsory acquisition can be achieved by the state. So that Chapter 65:02, acquisition of land for public purposes, has now to be interpreted and construed against that background. So that if compensation is not adequate, or if the payment is not prompt, the acquisition is unconstitutional and therefore bad. Your Honors, it is the law that adverse possession is prescribed as giving an entitlement to ownership through adverse possession by an adverse possessor. But compulsory acquisition is based on something completely different. It's based on a different enactment. It is based on acquiring things for public purposes. And this has to be achieved within the provisions of the Compulsory Acquisition Act, and they have to be interpreted in harmony with Article 142 of the Constitution. Consequently, I submit to Your Honors that Clause 2A6 of Article 142 of the Constitution, which relates to the limitation of actions, does not affect the substance of the basic requirements touching compulsory acquisition. It cannot be used as a provision to enable what is being claimed here, namely that the state can possess an individual property through compulsory acquisition law, and years after, when that law is struck down and deemed invalid, it can proceed to still claim it and keep the property by virtue of the original owner's handicap, namely is being estopped from by any limitation of action. Your Honors, wish to place on record our support here today for all that we have recorded in our written submissions. We support all that is recorded there and was filed in the registry on the 27th of March 2008. More particularly, we specially endorse all that we have said under our closing points. The appellant's presentation, that is to say, its evidence before the Lawrence Chief Justice and its findings should not be overlooked. And we rely on what the Chief Justice said at pages 43 and 44 of the court's records, remembering too that the Chief Justice found that there was no adverse possession at the time when the appellant took or was given possession of the premises. The appellant's case, Your Honors, is mounted on an unpardonable plethora of untruths. Your Honor's attention is specifically directed to the paragraphs of our presentation, which sets out 5 or 6 points. I do not have the time to go into those, of where statements were made that are far from true. Your Honors, the appellant stated that they did not know, the appellant stated it did not know that there was a challenge to the acquisition orders and that they were struck down. Apart from our drawing attention to its application to intervene in the Court of Appeal at the Court of Appeal stage, we should like to draw the Court's attention to the premises on which it sought intervention in the Court of Appeal. And ask Your Honor's attention to page 655 of the record, paragraph 18 of the affidavit sworn to. It said before the Court of Appeal, it stated, if the judgment of Justice Kissoon was upheld, it would mean that Toolsie Persaud Ltd was always in unlawful possession of F, G, and H, and they would be compelled to remove. Those are their words. Paragraph 18, page 655 of your report.
Mr. Chase, wasn't that being said by Toolsie Persaud, who is a layman as far as I understand it? And if he had a misconception about the legal basis of his claim, should that be used against him?
Very good question. The affidavit was drawn by a distinguished senior counsel in Guyana. You see that in the affidavit, drawn by him. And I don't think he put in a legal point which he didn't feel had some substance.
But are you referring to what is in the affidavit or to the viva voce evidence?
No, what's in the affidavit? Sworn testimony. When you look at it, paragraph 18, it states that if the judgment of Justice Kissoon, this is a legal point, was upheld, it would mean that Toolsie Persaud Ltd was always in unlawful possession.
But isn't that a question of law? How does a layman make a point like that? Yeah, he says that, this is what the lawyers tell me, but I don't know anything about it.
There's many cases.
Well, in the first place, I don't think you should be putting that kind of thing in an affidavit. It's law. Affidavits deal with facts.
I move on then, Your Honor. I move on by merely pointing out that the judgment was upheld, the statement was found to be in unlawful possession of the areas, and the legal position is that both constitutionally and statutorily under Chapter 65:02, the state was clearly in unlawful possession of the respondent's land. Your Honor, we also insist that there were many non-compliances with rules touching prescriptive title, and they were grave enough for the court to disallow the petition. To refer you to what the learned Chief Justice said from time to time about this. In particular, Your Honor, there is no mention of boundaries in the petition.
Mr. Chase, I'm afraid your extra time has run out.
Very well, I stop.
Yes.
Very well, sir. I was just going to come to something, but,
Yes, but
I stand by your ruling. Thank you.
We thank you. Mr. McKay?
Your Honor, I begin by saying that the state and the appellant were never in adverse possession of the land. As regards the appellant, the agreement of sale did not put him in adverse possession of the land when he entered, although he was given possession of it. Cases of Gunty and Horrell, Whitney and Farouk should be closely examined in the light of the decision of the Federal Supreme Court. which was given by Rennie CJ, who held that a purchaser who is put in possession pending completion is not in adverse possession and becomes only a tenant at will. If the appellant was a tenant at will, he cannot be in adverse possession. I need not say that to this court. Two things happen there. He remains at the will of the owner. In addition, the continuity of possession by the state, even if assuming the state were in adverse possession up to 1988, when they gave possession over to the appellant. There's no continuity of possession after that, because the appellant becomes a tenant at will and occupies the land not adversely. So that chain of possession, even assuming adverse possession by the state, is broken. And if the appellant wish to prescribe under Section 9(2) of the Limitation Act, his period of prescription will commence from the anniversary date of his being put in possession. That is to say, from 1989 onwards to 2001, when he can properly say that he had extinguished the title of the owners.
Mr. Mackay, are you saying that possession as tenant at will is different from possession as licensee? Because obviously if you have possession as licensee, your possession is regarded as a continuation of the adverse possession of your licensor owner. Is that also the case or not, no, where someone goes in as tenant at will?
No, I say he remains a tenant at will. The trend of authorities, and I've listed them in my submissions, Hyden Pierce and others, there is from this jurisdiction of Arafat, Khan and Guerra, decision reported in the West Indian report, where it was held that a purchaser becomes a tenant at will if he's put in possession after pending completion. But a trend of authority, there's also another authority from former Chief Justice of the Federal Supreme Court, Justice Rennie from Jamaica, I have attached a copy of that decision. And in that decision, the learned Chief Justice...
What's the name of the case?
I'm sorry, sir, I have it.
Bramwell and Gordon.
Bramwell against Gordon.
That's a Jamaican case, is it not?
Yes, please, sir.
And there is a Guyanese case which Fenton mentioned Ramlakan and Farouk,
Yes.
which might be more relevant. And that's a Court of Appeal decision when the Guyanese court was the final court of Guyana. Court of Appeal was the final
It should
court.
be examined by this court, which is now the final court for Guyana.
Yes, but are you going to tell us why we should examine it or how we should examine it?
Well,
What is wrong with, if anything, with Ramlakan and Farouk?
Well, Ramlakan and Farouk, in my respectful submission, does not elucidate its position, the position it took following Gonchi and Harrell, as did the Learned Chief Justice did in Bramwell and Gordon.
But the position in Guyana, in Jamaica, is not on all fours with the land tenureship in Guyana, is it? It's slightly a different system. It's the English system you have in Jamaica, whereas you have a different system in Guyana. And what I am suggesting is that the Guyanese cases might be more relevant than the decision of Chief Justice Rennie.
I do not submit to the fact that we have such different systems in respect of determining whether principle applies that a purchaser who is in pending completion becomes a tenant at will. I think that is dependent on the common law principles and not on the Roman Dutch law.
Go ahead, Mr. McGee.
The principle which I would respectfully submit to the court, which will explain my position, is the case of Cadogan and Cadogan, which was decided by Stobie J. as he then was, in the court of first instance. He went on to explain, Your Honors, how the courts have evolved with respect to the Roman Dutch system after the 1833 Limitation Act came into force. That the court nevertheless continued to apply the principles of the common law before, which took place before the Act of 1833. And principles which were at common law before the Act of 1833 was brought into the 1939 Limitation Act.
Mr. McGee, I don't want to stop you, but it seems to me that the question of the capacity in which the appellant went into possession of the land would be highly material if it was alleged that the state's title had been extinguished by prescription. But I would not want us to spend a lot of time on this issue if it was not really, did not really affect the outcome of any issue in the case. And here I go back to the question raised by His Honor Mr. Justice Hayton. That is, does it really matter whether the appellant took possession as a tenant at will or as adverse possessor or as a licensee, because if he was either a tenant at will or a licensee, the possession of the state would continue through him. And I don't know if you have any authority which sheds light on that issue, then I would be very interested in hearing it.
Well, the principle of a tenant at will is that he is in possession by reason, as was in this case, an agreement of sale. He was put in by reason of that agreement of sale. And he relies on that agreement of sale to say that he was an adverse possessor. That is the principle on which, and he says, the appellant says that he can tack on, following the known principles of tacking, that he can tack on years by the state, and that would bring me, then I can pass on to the state's possession, that the state's possession could not have been adverse until the nullification had taken place.
Yes.
The nullification order.
Well, again, if I may help you on that, I mean, we have read the written submissions, and we've heard already from Mr. Chase with regard to that, and we understand, I think, what has been submitted on each side. But you go ahead if you choose.
No, Lord, I'm subject always to how the court views are on certain matters. And if it appears that there is no need to proceed in it, to win a match, one doesn't have to score 1,000 runs if you have to make 100.
Well, I'm not saying we agree with your submission, but we know what they are. But you go ahead.
Your Honor, I have dealt with the cause of action. I don't propose to deal. I've dealt with the tenant at will. I've listened to the court's views carefully during the previous speaker's presentation. But one point is also of importance, which I believe, that the order for making a declaration as to the validity of the acquisition orders 23 and 22 and 43, they were made by a court even though the time had passed for the limitation period under the Prescription Limitation Act. That does not affect the right of the litigant then or thereafter to apply for possession of the land, even if, and I respectfully submit, that contained in the orders or the motions are redress, application for redress, out of which an order for possession could have been made.
But would those orders have been made in the absence of Toolsie Persaud Ltd?
In the absence of Toolsie Persaud?
I mean, they were the people in occupation. I mean, how could you get a possession order when the person who is in possession is not a party to the action?
Well, his possession commenced only in 1988.
No, but
But he knew of the action.
well, why didn't you?
I leave the matter solely with the submission made by Mr. Chase on why he knew and how he knew. And if he knew, surely, as a businessman, he ought to have guided his lawyer.
No, but
Application made to set aside the order by him in private law.
no, but if you got title and he remained in possession, he merely continued, presumably prescribing against whoever is declared to be the owner. If the owner does nothing, that's why I'm saying that to get possession, would you not have to make him a party and let the order bind him, let him come and say what his position is?
Well, if it is made in private law, yes.
So that in public law you can make an order against anybody in the state, even though he's not there physically.
Public law, the State Liability and Proceedings Act says that proceedings must be against the Attorney General.
Yes.
And that is what happened in the two motions filed by the second and third respondent. They filed proceedings against first and second respondent against the Attorney General of the state and asked for declaration setting aside the orders of acquisition and to make ancillary orders as set out in the motion. It was for the court, if it thought fit, or Mr. Persaud's counsel, if he thought fit, to ask the court to be made a party to the proceedings.
But didn't the appellant make an unsuccessful application to intervene in those proceedings?
That was at the Court of Appeal stage. An application was made to the court to be made to intervene. Yes, Your Honor.
But that was in the motion brought by the first respondent, was it?
Yes.
Yes.
What was the ground on which their application to be joined as a party was refused?
I think it's contained in the judgment of Kennard J.A.
Yes.
I haven't. The judgment is made. But it was based on delay, principally. That is the reason I believe I'm conversant with.
When was that judgment given? When was the judgment given in the Kisung jails?
Kisung?
19? That was on the way to the Court of Appeal.
In 1994, the Court of Appeal 2-1 rejected the intervention attempt.
Yes.
I was just saying in 1994 it was that the Court of Appeal rejected by 2-1 the attempt of the appellants to become a party to the appeal from Mr. Justice Kissoon.
What page is it on the record?
Well, you didn't take time on that. But I don't know if you can help me with the dates on which the appellant went into possession of the land
Well, the purchase was made in October of 1987. Sale took place on that date. And the evidence suggests that the appellant did not go into possession until 1 year later.
Well, April 1988. April 1988 is the sort of agreed date.
Because
no
there
dispute
was
about that.
a crop to be reaped, and the government, he had given possession, they had given possession to the government to remain and reap that crop.
And your action to strike down the compulsory order was in November 89, not so?
Yes.
Would not be more than 12 years after the...
Well, it was after 12 years.
Yeah.
But this was a constitutional motion. Now, I respectfully submit the time did not run against the second respondent. I refer to the statement of Justice of Appeal Chan at page 74 of the record.
Yes, what did he say? Yes, Mr. McGee, your time is slipping by, I'm afraid.
Well, I thought Your Honors might have been reading what Justice Chan said.
What did it say? Can you tell us?
Go ahead, Mr. McGee, you don't stop. You go ahead.
I would like to refer also to a decision of the Privy Council, about which I was just informed, where they dealt with the situation of an application being made 30 years after, and they did have something to say in the case from Court of Appeal of Trinidad and Tobago. I believe the name of the judgment I have not gotten is Blanchard and others against the Attorney General of Trinidad and Tobago.
Blanchard.
Supported my submission about time running against the applicant for constitutional relief.
Well,
Your Honor,
can you summarize what does it say?
the judgment, I understand, the Privy Council did not wish to hear counsel for the appellant on the issue where the time ran against the applicant for position, for who sought. So I must confess, I just this moment got of the decision, which I can undertake to send to court. I want to say one more thing with respect to the question of an interest in land, which arises in England or in the English, under the English law. The principle where a purchaser is put in possession of land pending completion he acquires an interest in land, unlike in Guyana, under our laws, such a purchaser does not acquire an interest in land, because there is no such thing as an equitable interest in land in Guyana. That has been ruled in several cases which I referred to in my submission. Principally, Kitty Village Council against Vera, 1961, LRBG 88 at page 91. I believe I've exhausted my time. And I don't wish to set a precedent.
But
I think you have about 3 more minutes.
Okay.
Could I ask you, I didn't quite follow what was the point on the purchaser who is let into possession pending completion. You were saying that English law gives an equitable interest. Guyanese law is different. And how does that impact on this case?
There's no equitable interest.
Yes, I understand that, but how does that impact on this case?
It impacts on the appeal because of the lack of an equitable interest. It cannot be said that the person is occupying adversely. A person, purchaser, put in possession, pending completion, cannot be said to be occupying adversely, unless in the 2 cases cited, Gunchi and Horel, and Farouk and Ramlakan, purchase prices were paid off, and they followed bridges and knees.
Yes, but I come back, Mr. McKay.
Yes, sir.
To the point I made before. That is, it would seem odd to me on the face of it that a person who is in adverse possession of land, and if that person puts someone else into possession in whatever capacity, that there should be an interruption of the time which is running against the true owner of the land. If within the next, within a reasonably short space of time, you're able to, you or your junior can find any authority which sheds light on that issue, then I would ask that you let us have it reference to it. But you understand the point I'm making.
I do understand, sir.
You assume the state is in adverse possession. Assume. And it puts the appellant in possession. How does it come about that the true owner who is out of possession gets a reprieve? I don't know.
Yes, how can there be an interruption there? But one further point to clarify and help the court, I think, is I see that on the 17th of April, you faxed to the court a copy of an extract from the Register of Deeds showing that your client, Shivlochnie Singh, transported the property in Area C to Raymond Alston on the 23rd of the 9th, 2004. But I also see, of course, that on the title of the papers we have Shivlochnie Singh, and then in brackets, by order of the court. But I can't see in the record any order of the court allowing Shivlochnie Singh to act on behalf of Raymond Alston, who now appears to be the owner of Area C.
All I know Your Honor, is that having been advised that there was a sale and transport of the property to Raymond Austin, I thought it desirable that the court should know of it. And that is why I sent it. I did not investigate the sources of authority, because Shivlochnie Singh herself, I believe, signed the document, signed the transport, if I'm not mistaken. I don't know about Raymond Austin. If you give me 1 second, I have it.
Right. Okay. He should have a second. The order the court is allowed to represent.
No, Your Honor, I don't have it here, but I can investigate that.
Because presumably Mr. Raymond Austin must have authorized you to defend his land, so to speak, via Shivlochnie.
I've never been counsel to Raymond Austin, only for the second respondent.
You see how it's a bit odd. If the land doesn't belong to your client, Shivlochnie Singh, why are you here defending the land if it belongs to Robert Austin?
No,
Raymond Austin. Yeah.
I'm here because Shivlochnie Singh is the second respondent, and I'm asked to appear on her behalf.
Yeah, she entered an opposition.
She entered the opposition with her husband, who's now deceased.
Very well, Mr. McGee. I think you have now exhausted your time. So thank you very much.
As it please you. I will take your query under advisement.
Thank you.
With respect to the possession.
Yeah. Mr. Attorney, would you like to address us?
Yeah.
Yes, go ahead.
May it please you, Your Honors. Your Honors, I would be grateful if Your Honors were to have before you submissions of the appellant. And I would ask you to look specifically at paragraph 28.
Yes.
My first submission, sir, is that with respect to the several issues that have been raised, there is no specific reference by the appellant to parcels K, N, J, and O. In relation to those issues. It is only at paragraph 28, under the heading, if the appellant fails to establish its case, do any of the consequential orders need to be made to clarify any relevant land titles? It is of significance, Your Honors, that the appellant's position with respect to parcels K, N, J, and O could be put into the following category. 1, there is an admission by the appellant that there was no challenge to the acquisition of K, N, J, and O. And as a result, the validity of the acquisition cannot be an issue. Your Honors, it is also of significance at the page which follows 28 that what is being claimed by the appellant is what is stated in these terms. The appellant submits that there can be no resistance to the appellant's title to these parcels in any event on the basis of its long possession. My submission is this: there is no claim insofar as those parcels are contained of any adverse possession. And that is emphasized.
What do you understand by title by long possession?
Well, I don't understand. Your Honor, the way I put it this way is that a claim for prescriptive title is a special procedure which is based on adverse possession. What the appellant was seeking to do here in this paragraph, under this heading, was to transform a claim of prescriptive title into a writ of summons for specific performance.
Let me just
Despite the fact that those words are not
just
used.
a minute. Would you just repeat that?
Yes. What the appellant was seeking to do was to transform a petition for prescriptive title based on adverse possession to a claim which can only be brought by a writ of summons for specific performance. And when they use the expression, Your Honors, long possession, it is in contradistinction to adverse possession. And they emphasize that position. Then, in the same paragraph, this statement appears. The private owners, and it is said to be H, K, N, G, and O, did not seek to set aside the acquisition of these or to enter opposition. The appellant will seek a declaration that its claim to parcels K, N, J, and O was not affected by the orders of Kisunje and the Court of Appeal, etc. And they gave a rationale why that is so.
Mr. Attorney, in order for the appellant to get a specific performance of the agreement for sale, it was necessary for the appellant first to get rid of the paper title of the first and second respondents, which had been reinstated by the relevant court orders, was it not?
Yes, sir. That is in respect to the plots owned by the first and second respondent.
Yes, but it was an agreement a single agreement, which covered all these areas.
Yes, sir.
And obviously, if it was cutting for specific performance of the agreement, it had to bring one action in relation to all of the areas. So that, I mean, the point that you make reflects a query which I had raised this morning as to whether the result which the appellant seeks can be wholly achieved in these proceedings, since they appear on the face of it, the result that they seek, it appears to involve, to some extent, specific enforcement of the agreement.
Of the agreement.
But the point I'm making is that there were two things that they had to do. But one of them was to get rid of the paper title of the two respondents.
Your Honor, in the course of Dr. Ramsahoy's presentation, he adverted to the fact that the state had acquired assets of the sugar company. If you look at the exhibits, Your Honor, Exhibit A, which is the plan, you will see annotated on that plan a memorandum. And the memorandum states that the various owners were, with respect to KNG and O, were Guyana Housing, were Enmore Estates, and a person named as Chung Wee. Guyana Housing is a state corporation, Your Honor. Enmore Estates, assets of Enmore Estates was transferred to the government of Guyana as a result of the nationalization. So it was the government, and that is what, on the evidence it was led, at the hearing, at the trial itself, that the KNG and O were owned by the state of Guyana. Perhaps it may have been felt that because you had other plots which were going to be sold to Toolsie Persaud, that it may have been considered necessary to have acquisition orders. But the state had owned K, N, J, and O.
Quite apart from any acquisition order, is that?
Quite apart from any acquisition order, sir. Dr. Ramsahoy referred to the... And
well,
in fact...
Is it that they were owned by the state through state corporations?
To the corporations.
One corporation or three?
Guyana Sugar Corporation and the Guyana Housing Corporation.
And the Enmore Estates.
Three names.
Yes.
What was the third
Enmore
case?
Estates is the one you mentioned, or was there a...
I'm sorry, sir?
You said Enmore Estates was another
yes,
owner?
Enmore Estates was a sugar company.
And Mr.
And what
Chung.
happened?
And was there a Mr. Chung also?
I'm sorry, sir.
Was there a Mr. Chung who owned one of those?
Well, that was one plot. That was separate and apart from Enmore Estates. What happened, Your Honors, is that after the nationalization, the property owned by Booker's, Enmore Estates, and all the other estates was vested in the state. So that, and the Guyana Sugar Corporation, Your Honors, and with respect to Plot N, there was a conveyance by East Coast Estates to the government of Guyana. And the government of Guyana subsequently transported that plot to the Guyana Sugar Corporation. So that on the evidence that was led at the trial, all the plots, the only plot which there is some concern or issue about is the plot described as owned by Chung Wee. But other than that,
Chung Wee.
Chung Wee, Your Honor. Your Honors, could you please look at the Exhibit A, Your Honor. And you will see... I don't have it. Yeah. Okay. But could I look at it? There is a...
Are you referring to the memorandum?
To the memorandum and the description, Your Honors, and then proprietors.
Oh, yeah. Proprietors.
You have the memorandum, sir,
Yeah.
which states, etc. This survey was carried out as a result of Order 22, dated so and so the Minister, etc. And Section 3. The purpose of the survey was to define the boundaries of plots and to set out the plots, etc., required for the siting of the diplomatic complex. And then you have notice of intended survey was served on the Chief Engineer Roads of the Ministry of Works and Housing, Mayor and City Council of Georgetown, General Manager of Transport and Harbors, Diaby, all being proprietors of adjacent lands, Shivlochnie Singh, Andrew James, Albert Changwi, the General Manager of Guyana Housing Corporation, and the Chairman of Guyana Sugar Corporation. And then you have the annotation, sir, lower down on the plots are set up. Plots. And then you have proprietor and title and the area of the acreage. Plot V of area C, Shivlochnie Singh. Transport is referred to, and it is 9 acres. Block 3 of area C, Shivlochnie Singh, 5 acres. Area F, Andrew James Investment, Transport, 6 acres. G, Andrew James Investment, 4 acres. H, Andrew James Investment, 4 acres. And K, Albert Changwi, 10 acres.
K, well, K is
Changwi.
Changwi.
Yes, sir. And then N, Guyana Housing Corporation. And J and O, East Coast Estates.
That was owned by the Guyana government, was it?
And with
East Coast was owned by the Guyana government.
I'm sorry, sir?
Was it owned by the Guyana government?
Guyana government, sir, because it became vested in the Guyana Sugar Corporation. And it came vested under the Vesting of Property Acquisition by Purchase Act 1975. That is when the nationalization took place. Nationalization, sir, was done under the Act Vesting of Property Acquisition by Purchase Act 1976. And then
how big is it? But what has happened to Mr. Changwi?
well,
He owned 10 acres.
yes, sir. Your Honors, but at the time the survey after the acquisition order was served on Mr. Changwi, it is not clear, sir, what happened with respect to Mr. Changwi, except the evidence that was given that even that plot was being utilized by the government of Guyana through the Guyana Sugar Corporation. And if you look at the plans, Your Honor.
But he was never paid compensation.
Sorry, sir?
He was never paid compensation.
Well, Your Honors, let us, the way I would wish to answer you is this way. I am not sure as to how it was. that the Guyana Sugar Corporation, because when you look at the land, sir, it is one plot of land. But you will see area A, N is adjacent to the public road. A is then adjacent to the railway line. And 4, what is your name? It's at the end, at the canal. So it would appear, Your Honours, that in view of the fact, and then you have Shivlochnie Singh and Andrew James abutting the public road. And when you look, it is one block of land. But this block comprised of several plots. And it could very well have been that because the idea was to enter into an agreement of sale with Mr. Toolsie Persaud for the entire block, it may have been felt necessary that despite the fact that the KN was owned by the government, they still went ahead with this acquisition order. Your Honours, I don't know all the details and I have been unable to get all the details because this occurred in 1977. But at the end of the day, sir, my and I will now report East Coast Estates. I'll put the order so that Your Honours was made under the Acquisition Act, and it states all the assets and liabilities. You will see under order, the agreement means the agreement made and entered in 1976 by the government, Booker's McConnell, and several other companies incorporated in it. Hereby directed that the Act shall be subject to Section 4. In its application to the agreement, the Act shall be construed and have effect as if the references to, let's say, 1, 2, and 3 of Section 4 shall be to the state insofar as this section applies to the transfer and vesting of A, the assets and liabilities, if any, of the following: Lemon Sugar Estates Limited, Booker's Sugar Estates Limited, Booker's Sugar Estates Limited, East Coast Limited, I suppose as Enmore Estates Limited, Ogle Company. So all the sugar estates or the holdings of the sugar estate vested in the government of Guyana. And it is of significance, sir, that when you look at a specific conveyance and transport, which is referred to as transport number 2070. It is a conveyance by East Coast Estates Limited to the government of Guyana. And thereafter, the government of Guyana conveyed that said property to the Guyana Sugar Corporation, is it? Guyana, sorry, to the Guyana Housing Corporation.
This would explain why there's never been any challenge of the acquisition of these lots, these areas. But the position, your position, in relation to KG and FG and H and C, what is your position? That as far as you are submitting that the court ought not to disturb the title of the first and second respondent?
Your Honours, the position I took at the hearing, the trial before the trial judge and at the appellate court, was restricted to K, N, J, and O. And the position I had taken is that the setting aside of the acquisition orders, did not affect K, N, J, and O. And in any case, there was no claim by the applicant to prescriptive title on the basis of adverse possession. And that is why I'm adverting Your Honor's attention to what the submissions have been to this court. And at the paragraph 29, sir, it is of significance what they have claimed. And then setting out the circumstances, sir. They're not claiming prescriptive title, Your Honors.
But you know, Mr. Attorney, in relation to the lands that were owned by the first two respondents, issues have been raised that are of some constitutional importance. And I wondered whether you would not have some position in relation to them. I mean, it has, as I understand it, it has been submitted in writing, though not orally, that the state can never acquire land by adverse possession. It is all, not so, isn't that
Could I very briefly respond to you, sir?
Yeah.
The submission of the state is that the state can never be in adverse possession and claim an entitlement of prescriptive title to private property. That the only mechanism available to the state for the acquisition of private property is provided for in the Constitution in 142 and in the Acquisition Act. And it is only based on the payment of compensation. Any entitlement to give to the state another right to private property without the payment of compensation based on adverse possession would be inconsistent with Article 142. And in any case, Your Honors, when you look at the legislation, there is no mention whatsoever for any entitlement by the state. It's only to extinguish title of the state when it must be by 30 years. So if assuming for the sake of argument that the state was entitled to claim private property on the basis of adverse possession, what is the period of time within which that claim has to be?
Well, the answer clearly would be 12 years.
Well, Your Honors, I am saying that since there is no specific mention of that in the legislation, then it is...
But I just want to ask you then,
Yes,
that you are treating the acquisition of land by a prescriptive title as being a form of compulsory acquisition. Is that right?
Yes, sir, as a form of acquisition by compulsory mechanism.
No. What the Constitution forbids relates to the compulsory acquisition of land or interest in land.
Yes, sir.
And what I'm asking is that therefore it would follow from what you have submitted that you regard the acquisition by adverse possession as a form of compulsory acquisition.
Yes, sir.
You don't see a distinction between the two.
I don't see a distinction in that assuming there is an entitlement to claim private property, then the result of it is a compulsory acquisition without the payment of compensation.
Well, I mean, that's, we don't want to play with words. But that is not as a result of some act of will by the state, but the result of an absence of action by the true owner. Not so?
Yes, it seeks to extinguish, Your Honor. Your Honor, may I be permitted, sir, if I was about to refer to paragraph 29.
Yes, go ahead.
Yes, sir. It is of significance, Your Honors, that this is how the appellant is approaching this court. The appellant in the premises seeks an order that the appeal be allowed and that it be granted a declaration of title to the parcels claimed or such for the other, etc. So they are basing the claim not on adverse possession, but as on possession arising from the agreement of sale. And if I might briefly, sir, refer to that agreement of sale, it is an agreement of sale which can be construed as a joint venture undertaking between the government of Guyana and Toolsie Persaud. And it is, if assuming the court was to make a declaration in the way in which this court has been approached, it would be to avoid those obligations which the agreement of sale obviously sets out. Your Honors, if I might advert very briefly to 518 and to 519.
Yeah.
The property sold to the purchaser, this is at 519, Your Honors, shall be developed as a housing scheme for all income levels, specifically the upper and middle income levels, and the purchaser shall prepare a scheme for the proposed development, setting out details in accordance with the second schedule of the Town and Planning Act, chapter so-and-so. Submit same for approval of Central Housing and Planning within 3 months. 8. The land development and physical infrastructure of the scheme are to be of a standard acceptable to the Central Housing and Planning Authority and the Mayor, etc., and shall not commence later than so-and-so. And 9, sir, a committee chaired by the representative nominated by the ministry responsible for housing and comprising a representative each from the purchaser, the vendor, and the Central Housing Planning Authority shall be established for the purpose of determining the allocation and cost of all lots and/or houses in the scheme. So, Your Honors, it is not as if the appellant was to get a carte blanche with conveyances. He was obliged to set up a scheme. The government was to be a party of this, and the value to be ascribed to each lot and to whom those lots would be sold was to be with the cooperation of the government. Your Honors, and then 10. Generally, land and or houses within the scheme shall be allocated only to persons who are not at the time of such allocation owners of immovable property elsewhere in Guyana, and shall be for the sole purpose of occupancy as a residence. Foreign embassies, high commissions, and other diplomatic missions shall be given special consideration in the course of each. And then you have another provision, sir. Persons or organizations desiring of disposing property allocated shall in the first instance offer such immovable to the Central Housing and Planning Authority for purchase or otherwise. So that, Your Honors, there were several restrictions which was involved in this agreement of sale.
Yes, I think, Mr. Attorney General, we see your point that we can't indirectly or directly, of course, specifically enforce this sort of agreement.
Yes.
So essentially, it seems to me, what you're saying is we should take a strict view of this petition, which is one where the petitioners humbly pray the Honourable Court will be pleased to declare that your petitioners are entitled to a declaration of prescriptive title in respect of the aforesaid lands,
Yes.
and in your case JKNO.
Yes.
And you're just saying we should dismiss that petition.
Yes.
That's the bare minimum.
That's the minimum.
The question is, do we go on and do anything
I would
about
say
anything else? or
not with respect to K and GNO.
Right.
Well, it's, you keep saying that,
Yes.
but whether you like it or not, there is also included in the petition a claim to FG, H, and C. Now, if despite your submission, if we do not accept your submission that the state cannot acquire land by prescription, and assuming that we also do disagree with the first and second respondents, assuming, and we hold that those areas, the title to those areas of the respondents 1 and 2 has been extinguished, what do we do then? What do we declare with regard to the person or entity in which the title should now be vested?
Your Honors, to be honest with you, I did not address my mind to that. And since you opposed the question, probably the court may consider a rehearing with respect to those specific plots of land.
A rehearing?
Yeah, Your Honors,
What? We can't, if we decide on the extinction of the respondents 1 and 2 title, that is res judicata. No question of rehearing. But, and also, with regard to the lots J, K, N, and O, there may be no practical possibility of a claim by the former owners. But one would normally want to, for completeness sake, make some ruling on whether such a claim could now be brought. But in any event, you see, there is this agreement to which you have referred, which seems quite a complex one, and under which certainly 1/3 of the purchase price has been paid by the appellant, and the appellant claims to have spent large sums of money in performance of the conditions of the agreement, in preparation of the land and so on. And you claim in your written submission that you have cancelled that agreement.
yes.
So that there are a whole bundle of issues arising between you and the appellant with regard to rights and obligations under that agreement. What do we do with relation to that? Do we just say, well...
Your Honors, I
we leave it to you all to sort out or what?
But the position with respect to K and J and O is that they have not made out a case based on prescriptive title.
Yes,
and as a result, insofar as the appeal relates to those portions, that claim must fail. And you cannot at this stage transform a specific procedure mechanism under the Prescriptive Title Act to an entitlement to the reliefs which may be available in a specific performance situation. I'm grateful to Your Honours, and unless there's anything else.
Well, one question, because I can quite understand one has to leave these contractual issues on one side.
Yes.
But let's look at Area C, and let us assume, for the purpose of argument, that there is 11 years adverse possession by the state,
Yes.
followed by just over 1 year's adverse possession by the appellant. The appellant is saying, you add the 11 years plus just over 1 year, that means I've got the 12 years in.
Yes.
I now humbly pray for a declaration of prescriptive title in respect to the aforesaid land, and we have power to extinguish a documentary title.
Yes.
And on that basis, you could say, well, we should extinguish the second respondent's title, but what are we going to do as between the state and the appellant? On the face of it, we have to say the appellant has prescriptive title, but query if we need to add, but without prejudice to the earlier possessory rights of the state, because the appellant can't adversely possess against your rights until 30 years have elapsed.
I think that was the question the President was posing to Mr. Chase during his presentation, that the state would have had a prior right and a longer right, longer period, rather than the appellant in this case. Your Honours,
Yes.
that is all I wish to say.
I have-
Yes, sir. Yes.
Yes, I would like to ask you about the cancelment of the agreement. You submitted that you cancelled the agreement,
Yes.
but the other side doesn't seem to know that.
Well,
When was it cancelled? And I see the agreement says that that can be done on the payment of compensation for works already executed.
yes.
Was that done?
Well, I don't have the exact date, Your Honor. And I don't know. You see, the position that the appellant took is that they were not going to respond to any cancellation of the agreement, etc. They were going to be entitled to a claim based on adverse possession. They were no longer relying on the agreement as such, because the agreement they had only paid 1/3 of the purchase price.
I understand.
Yes, sir.
Yes.
And whatever development works they said that is done, whenever a challenge is made to the entitlement for specific performance, those issues will be dealt with, sir. Assuming there is still an intention on their part to pursue such a claim. And I'm grateful to Your Honours.
But, Mr. Attorney,
We won't let
Yeah,
you
yeah.
sit this yet.
I'm very anxious to know whether there is a document of cancellation. Why do you say that the agreement was cancelled? It must have been in writing.
Your Honour, I really can't answer you.
No, but where did you get the impression that the agreement had been
Well,
cancelled?
Your Honours, that is the information that was received at the Ministry.
Well, there's certainly no evidence led on that, was there?
There was no...
No evidence of it led.
Yes, but Your Honours, there was not an issue. It was not an issue in the proceedings which was limited to a claim for an entitlement based on adverse possession. That was the sole issue. It was, and Your Honours, if I might point out as well, this mechanism for an entitlement to prescriptive title could be heard other than in the High Court, because in Guyana you have a judge described as a land court judge. And normally a claim for prescriptive title would go to the land court judge, who is not sitting in the High Court as such. So there's a very special procedure. And that is why Mr. Chase, in his arguments, has advanced the rules that are required under that specific procedure, which is not applicable to a writ of summons.
But a petition of this sort could also be assigned to a commissioner, couldn't it?
Well, I think it's called land court judge, sir, I think. Commissioner, I'm advised that the person, I'm advised that the person is referred to as the Commissioner of Title, sir. But I think in local parlance is referred to as the Land Court Judge.
Just one practical question. It seems that under this agreement, Toolsie Persaud started to build or work commenced in '88. So it's 20 years ago.
Yes.
So what happened?
Well, Your Honor, that is why I'm saying, sir, that whenever that issue is raised, nothing has happened except on the incidentally during the application for intervention, there was some reference to work had been done in the vicinity of $20 million. But other than that, there's nothing on the land. No work has been done, and that's 20 years ago, and you had an obligation under the agreement within 3 months to take several steps, to do several things, sir.
Who is in possession of these lands now?
Sorry?
Who is in possession of these lands now?
The state is in possession of the land, sir, except for plots by Guyana Singh and Andrew James.
Well, what do you mean, except for which lots? Which areas?
That would be...
First is one, I think, second.
No.
First and second is one.
That's C, sir, and...
FG and H.
Yes, sir, FG.
So the appellant is not in possession of any of the relevant lands?
Not in possession of any... And in fact, Your Honours, they had indicated that the state was carrying out works on this land, and they were to raise that with this court. I know him, John.
But when was the appellant dispossessed?
Your Honor, during the hearing in the High Court, he had been dispossessed. When the petition, at that point in time, he had already been dispossessed.
Oh, he had already been dispossessed.
I hope Your Honours are not thinking of visiting the locus and Pusa.
No, not yet. Could you tell us a bit more about how the appellant came to be dispossessed? By whom was the appellant dispossessed?
Yeah, I know. Your Honor, what I could say, he is not in possession. He was not in possession at the High Court. The government has been in possession. The government has been constructing a swimming pool in one of the plots, and there was a response by Toolsie Persaud, and their lawyers responded and said that government should cease carrying out the work. The government has not ceased carrying out the work. It is continued. But because it's a large block, sir, the government cannot specifically occupy any particular portion as such. And this swimming pool, I believe, is being built on a specific block.
But did the appellant spend money on the land?
Your Honour, as I said, sir, during the application for the intervention, there was some evidence led that he has spent $20 million, and as a result of it, he was entitled to intervene. It was not led as such at the hearing.
But in cross-examination of Mr. Toolsie Persaud, he said that he spent $22 million.
Yes.
Or his company, anyway.
Yes.
But surely the state must be in a position to know whether there were improvements made to their land, whether by the putting in of infrastructure.
Perhaps, if only for that reason, sir, perhaps your lordships might visit locus, sir. You will see that there has been no improvement, nothing done, except, I believe, some trenches or something. Not other than that, nothing has been done. Yeah.
Right.
And I think on the evidence, Your Honors, there was work done with respect to and it was done by the Guyana Housing Corporation. That is the evidence at the trial.
But is the state prepared to give back to the appellant its money? Part of the purchase price it paid.
I'm sorry, sir, I couldn't.
Is the state prepared to refund the money paid on account of the
Your Honor, on
purchase
the
price?
agreement itself, that is what is stated there.
What is stated?
There is an obligation on the state, sir, to refund any money. It's the condition stated that.
Yes, but that is what is in the agreement. I think what the learned president was asking is whether you are prepared to.
As Attorney General, I am saying, sir, that if Mr. Toolsie Persaud can establish that he has spent money, it will be refunded.
Even if it's 22 million.
Sorry, sir?
Even if it's 22 million.
Even if...
It's 22 million.
Yes, sir.
Yes.
Even if it... Your Honor, I don't know how I should say this, but the value of 83 acres of land in that location would be in the vicinity of billions.
Oh, billions.
Billions, sir.
Now.
Well, so much for the hope of a settlement.
And the more I think of it, sir, I would be very pleased if your lordships were to visit Guyana only for a day to see the location of this land. Could I be excused from the lectern for just 1 second?
Yes, certainly.
Yeah.
I have one other question.
Yes, sir.
In '92, there was an advertisement by the government of Guyana for transport of KNGNO.
Right.
So at that point in time, you were planning to transfer that property to Toolsie Persaud.
Toolsie Persaud. At that point in time, sir, the intention of the government was to convey the property to Toolsie. But then they did not follow through with that intention. And there was a later occasion during the appeal stage when there was an advertisement. And that advertisement came about in this way, Your Honors. Whilst the appeal was pending, Mr. Hughes wrote a letter to the registrar without the knowledge and consent of anyone else, compelling the registrar to re-advertise. And when the re-advertisement took place, it was stopped. And they complained to the appellate court that this property was advertised to be transported, and it was stopped. I think Mr. Singh is the one who mentioned to the court. I did not give the rationale as to why it had been stopped. But, Your Honors, as my Lord Nelson said, sir, once Toolsie Persaud can establish that he has spent sums of money, either 20 or 22, whatever millions he claims, on the basis of as provided for in the agreement, as the Attorney General, I am indicating to the court that that money will be refunded. And unless...
One final question. Assume again that we were to find that the title of either the first or the second respondent, or of both, had been extinguished by their failure to take action sooner. I must ask you, what would you wish the court to do in those circumstances?
Milad, it seems to me that it would be difficult to separate this agreement. Difficult to separate the agreement. The agreement must be considered as a holistic agreement relating to an entire block of land. And on the basis of the fact, sir, that, Your Honor, the difficulty that arises in this case is as published, as presented by my Lord, that it seems as if Shivlochnie entered into some agreement or something. So, well, I don't know what, my learned friend is saying sold, I don't know what he means by that, with Mr. Austin with respect to C.
What she has done or not done, cannot affect the decision in this case.
It should not affect it, sir.
What I'm trying to ask, what I'm trying to find out, to come right to the heart of the matter, if now in those circumstances that I mentioned, since if we take the view that we cannot resolve the respective rights of the parties under the agreement for sale,
yes, sir.
The state as the having prior possession,
Yes,
to the appellant would have a better right to have the paper title vested in it. Yes.
Your Honor.
And so that we would then, if those things happened, if we came to that conclusion, then the answer might be that we would, the prima facie, the order would be to vacate, if you like, squash the title of the first and second respondents, and to order that their land be vested on the face of the record in the registry in the state.
Yes.
Is that a result that the state would find acceptable?
We have no objection to such a conclusion.
Reluctantly, but you would reluctantly
welcome
accept it.
Such a conclusion. But, Your Honors, I could assure this court, sir, that whatever order is made by this court, the government of Guyana would be advised to abide by the order. And in any way where there is some injustice or some person has lost or that will be compensated. Your Honors can be assured of that.
Yes. Right. Thank you, Mr. Attorney. Yes, Sir Fenton, would you like to reply?
My lords, there are three things. One is that in relation to the recovery of possession, it has to be remembered that these proceedings for nullification were conducted with the appellant being in possession at the time, and with great resistance, successful resistance, to him being allowed to become a party to the proceedings. Because had he been allowed to become a party to the proceedings, then whatever result would have come out of the proceedings would have bound it. As it is, he was never a party to the proceedings, and he was always in possession. There is no explanation as to why he was not joined in the proceedings. When he tried on appeal, that is when they began the proceedings, he was not joined. And when he tried to intervene on appeal, his attempt was resisted.
But why didn't the appellant try when the case was in the High Court?
because I don't know why he didn't apply to be joined in the High Court, my Lord. I don't know why.
Yeah.
But I would say, my lords, that having regard to the fact that there was no real dispute of fact, but it was only entirely legal issues which were fought in the Court of Appeal, that he could have been joined as Justice of Appeal Bishop at the time thought. That's why he dissented when they refused to allow him to intervene. Now, the next thing, my lords, is that there is, because of the nullification, a complexity. We say that when the nullification came about, that the state's possession for the 11 years was not bolstered by lawful authority. And then that was continued by the appellant. If the combined periods meant that a title is to be declared, an issue may arise as to what share the government, the state, is to have in it. But the state is bound to us by an agreement whereby we paid them 1/3 of the money and we owe them 2/3. They have never suggested that we didn't do all the things which the agreement required us to do. As a matter of fact, my lord, the evidence would show that when we went in 1988 and began to expend the money to do the development, because it was to be a housing development, so it means roads, drains, and all the facilities had to be put in, and approval had to be given by the Central Housing and Planning Authority for what we were doing, which we got. So we were trying to perform the agreement, and we have always been willing, but the state has reneged on the agreement.
Well, Dr. Sir Fenton,
and there's no justification.
But you know, the appellant chose to come by this form of action, which focuses really exclusively on prescription.
Yes.
And therefore the form of action did not cater for the ventilation of the issues which may and obviously have arisen with regard to the performance of the agreement. Now, I don't know that it lies with the appellant now to ask us, on the basis of the evidence that there is, to proceed on the basis that the appellant has performed all its obligations, and it is the state and the state alone that is in default. I don't know that that would be fair.
I can see that, my lord. I can see that. But when, in the final analysis, the appellant's main case is that there was adverse possession for the statutory period. That is his main case, of which the state was in for part of the time, and the appellant in for part of the time. That's its main case. I mentioned the agreement because the litigation, which began in 1989, served to torpedo the arrangements. But having heard the Attorney General now, I'm obliged to say that at some time after that agreement was made in 1987, the state decided that they wouldn't proceed with it and wouldn't take any steps, which as a state they had power, and at the time they had sovereign power. They had dictatorial powers. And they didn't make any attempt to perform the agreement. So we are left with the position where we were in possession, we followed the state, petition had been duly advertised. At page 474 of the record, that is the judgment of the Chief Justice, your Lordships will see that he said they were private owners. Changwi, Guyana Housing Corporation, East Coast Estates, owning KNG and O. And the position in relation to those is that there was no opposition entered by them. But the claim to prescriptive title in this case is in relation to the whole area of land. And that is the area that the government intended to sell to the appellant and which the government put the appellant in possession. So that we were in possession of the whole area, all the parcels. Today, the government has forced its way back onto the land and it's building swimming pools and doing other things about which I've complained by letter. But as far as this appeal is concerned, our submission is that when we brought this case in 1993 January, the titles of the private owners had been extinguished. That's our opinion.
But you see, again, assuming that we were to find that the title of one or other or both of the respondents had not been extinguished, then so that it is not possible to give effect to the agreement for sale in respect of part of the lands. How can we give effect to part of the agreement or to give effect to the agreement in respect of part of the lands? How are we going to determine, for instance, what portion of the purchase price should be payable in those circumstances? It's an impossible task.
That could not be done. That exercise could not be undertaken without some form of inquiry directed by the court. If it were to come to that, that would be it. There would have to be an inquiry. Your Lordships, on this record, would not have the evidence of values into that. There would have to be an inquiry into it.
Well, the question of whether the appellant, having chosen to confine itself or to come by way of a petition under this act, is really entitled to have an order for an inquiry of that sort, or whether the appellant should be left to take such action as it may be advised.
On the face of it, this is just one battle in the course of a war. Hopefully it will clarify an awful lot, so one further action or mediation or arbitration will settle it. But I don't think we can really do it ourselves, although I note you're suggesting we should, by way of an aside at the end of the judgment, perhaps say the best way ahead, if we had authority, would be as follows. But I don't think really that would be a legitimate process for us to adopt.
Your Lordships have seen the course of the case, seen what has happened in the registry, out of it, in the courts, and the consent order which was made on the 1989, second 1989 case. So your Lordships have a very good idea of what the course of legal proceedings was in Guyana in relation to this case. I must confess that I find it all truly astonishing what has happened here. I don't practice there for the same reasons. All I can do is to leave it in your lordship's hands now. I think I put
You have, before you do that, I don't know if you have any
possession, and I don't see, my lords, what will be done to put us out except by force. We are still in possession, even if they are building swimming pools against our protests. We are still in possession. They have no right to go there. Even when this case is before the Caribbean Court of Justice, we've had this appeal going on here, pending in this court, when they began to build swimming pools on the place. And passing conveyances while the case is going on before this court. There must be some respect for the judicial system. The rule of law requires it. If we are going back to the rule of law in Guyana, and that is the step we took when we re-established a third court, this is what has to happen. The rule of law has to prevail.
Well, I think the transport that was passed was not by the state, but by the second respondent.
Well, yes, the value of that depends on whether the title was extinguished when they passed the transport.
Anyway, but so that your instructions that the appellant is still in possession. We were told by the Attorney General.
She is still in possession, but this there is a conveyance passed by the owners of Area C.
Yes.
The Attorney General said it was passed to Raymond Austin. I believe there are other conveyances for Area C passed too, but I am not familiar with what went on. But what I do know is that it all happened while the case was before the courts. This case.
Well, I mean, if they want to take a chance on the outcome, then that's a matter for them. I don't consider it a contempt of court, but I don't think that our decision is going to be affected by that. But it's a pity that we cannot have agreement even on such a basic question as to who is in possession.
Our people are in possession, but in recent months, a swimming pool is being dug on a part of the land. That is what I know. A swimming pool. No buildings have been put on the land yet. There have been drainage works done. We did some. Place was laid out and approved by the Central Housing and Planning Authority for the housing scheme, which we did. All that is in place. But there is no construction, but there's a swimming pool which is being dug there now, and we have been protesting it and telling them that the matter is before the Caribbean Court of Justice and that it shouldn't jump the gun to do that. It's not that they will want to take any notice of us. The Attorney General has made it clear that he's cancelled the agreement. There is no evidence to justify such a force. Agreement is reneged upon. And the Attorney General says that in the face of it.
So, Counsel, if TPL is in factual control of this land, why don't you just throw them out? Eject them.
Why don't we just throw them out? Because we want to have
Well, it's the same reason, my lord, the same reason. The same reason. A legal system is there to try to do its best to ensure peace and security. That's what it is there for. We can't do that. But they're trying to force us out, and the state has the coercive forces of the state behind it. It's the army, it has the police. We've gone a far way.
So are you then suggesting, counsel, that the compulsory acquisition order is in fact some indication of force behind it?
No, the compulsory acquisition, but the Attorney General says that the state had already owned part of this land, yet they made an order to acquire it. I don't understand that. I don't understand that at all. Don't understand what was in their mind. And then caused litigation, which they resisted before Justice Kissoon in relation to the nullification of the orders.
But whatever happened?
It was part of it. Why did they acquire NJO, KNJO if they owned those lots already? They didn't have any need to acquire those if they owned them already.
A question which no one need answer is what happened to the diplomatic complex? But
oh, the government.
I said you didn't answer it.
No, the government had intended to do this thing. And then afterwards they decided that somebody else must do it and spend the money to do it. And they didn't want the diplomatic complex as such anymore. The agreement tells us that they wanted a housing scheme in which diplomats will get houses in there. But somebody else had to provide the money, i.e. the appellant, and they were to have a committee which would be in control of not only the allocation of the lots, but the cost of the lots. So when the appellant entered into this agreement, he entered into a compact with the state, whereby he would develop, and they would have a committee to determine the cost of the lots in the development. Diplomats were to get, and other people were to get for housing. The agreement of 1987 was a fair agreement by a government that wanted to make provision for housing as well as for the diplomats who would come.
Well, this land was acquired in 1977. They were growing grass on it in the meantime. Anyway, let's not take time on that. We have many more difficult questions to resolve. Well, I don't know that. I don't know if you can help us any further, but my area in which I would have welcomed assistance is the form of order which we might take in the event that, well, which we should make in relation to JKN&O, and in relation to any of the other parcels in respect of which we may hold that the title of the respondents has been extinguished.
Well, would your lordships then grant leave now for the council to make submissions in writing?
Well, I don't think we can delay this any further, but on the other hand, I am anxious to receive as much help as we can get. So I think what we can do is to give liberty, give leave to all sides to make our submissions in writing on that issue. The issue, if I may remind you, is in relation to JKNNO
Yes.
and in relation to so much, if any, of F, G, and H and C as we may hold has been in adverse possession, that is for more than 12 years.
Yes.
What is the order which the court should make? If we find that, for instance, either of the first or second respondent's title has been extinguished by prescription, we can so declare. But should we do so without going on to identify the entity or person in whom that paper title should now vest? And if so, who is that entity or person? And in this regard, there are complications created by the rights between the appellant and the state, depending on issues arising out of the performance of their agreement, which had not been ventilated. Also arises because of the possibility that in respect of a portion of the land, the subject of that agreement, the title will remain in one or both of the respondents, so that the state will not be in a position to convey it. Well, I think I've said enough to indicate that at any rate at this stage, the area of difficulty in which we would be glad to receive submissions if the parties, any of them, feel competent to make suggestions. Of course, these problems would not arise, or would not arise in relation to the parcels C and F, G, and H, if we find that there has been no there's been no barring of the respondent's title. That is something which has not, of course, yet been decided. And we would ask that if any parties are going to send us their written submissions on this area, that they do so within the next 14 days at the outside. And the sooner the better. Okay. All right, well, we thank you, Dr. Sir Fenton and the other counsel for your assistance, and we reserve our judgment.
All right.